All right, so ladies and gentlemen, good morning, good afternoon, good evening, depending on where you are. Welcome to the first edition of the Lear Competition Festival. As you might know, our original plan was to hold the festival in Rome last year. And I do not have to tell you why we have been forced to change this initial plan and eventually opt for an online edition. I think this is an unfortunate decision, and for many reasons. Well, the first reason is that we are missing the opportunity to meet old friends and colleagues in person and the chance to get to know new ones. But there is another reason that is specific to the event you're going to take part in. And indeed, our ambition is to create a new occasion for meeting and discussing about competition policy. And when I say new, I actually do not mean an additional one, but rather a different one. So let me take this opportunity to share with you the idea of the festival. Now, using an expression that is fashionable these days, the Lear Competition Festival would be a platform where all antitrust stakeholders will be able to meet, and a platform with several functionalities, so to speak. So first, the platform will be available to have conference-type meetings. However, while we will organize some plenary sessions, the festival will also host sessions organized and managed by our partners. These sessions will be held in parallel and will be named know-how sessions and hot cases sessions. In this virtual edition, we have a number of partners, and I want to thank them for their fundamental contribution to the festival. They are the law firms Freshfields, Bruckhaus, Deringer, Osborne Clark, Dentons, and Doric. And then we have Digicom, the OECD, the EBRD, and UNCTAD that are going to contribute to the festival. Second, the platform will be available to our media partners. I want to present their editorial output and publications. And let me thank in particular our media partner PAR for the contribution to this virtual edition. Third, the festival will be a platform for young talents that want to pursue a career in our field. During the festival, they will have the opportunity to meet the future employees, hopefully, law firms, consultancies, companies, competition authorities, regulators, and international organizations. And indeed, a specialized job market will take place during the festival, thanks to a web-based platform that is already available on the web, and it's called Talent for Comp. Now, holding the job market was actually impossible in the virtual edition. Yet we decided to retain one specific initiative, which is the Young Talent Competition Award. We have asked young lawyers and economists to submit their research proposal, and then a scientific committee that is formed by Michele Carpagnano, Bill Kovacic, Joe Harrington, and Tommaso Valletti has evaluated those proposals, and 3 have been selected. The authors of this proposal, we have the opportunity to present their research projects today, and at the end of their presentation, the winner will be announced. Fourth, the festival will provide all members of our antitrust community to meet in the exhibition areas, at our partner stands, at the gala dinner, and other social events. So I hope you'll find that these features of our platform are of interest to you. So we look forward to meeting you in person next year. And please get in touch with us if you're interested in becoming partner of this initiative. We are open to hear your proposals and suggestions for the 2022 edition of the festival. But for the time being, let's get started with the 2021 edition of the festival, and I will present right now, the content of the festival. Okay, we're going to start with a plenary session. Today we have 3 sessions. The first one will be about a very much debated issue, which is whether competition law design and enforcement should be guided by distributive goals too. We have 4 wonderful panelists, and Alberto Pera will chair this session. Then, okay, maybe I can shoot this one, okay, this way. Then we have, sorry, okay, that will be the first session managed by our partner. This session will be managed by Freshfields, and will take up a very hot topic, which is the digital, the assessment of digital mergers, in digital market. And then we will have the Young Talent Competition Award. So stay tuned to hear from the members of the scientific committee, and especially from the selected projects. And then I guess you don't want to miss the opportunity to know the name of the winner. Okay, tomorrow we will start with a roundtable with the chairperson of some national competition authority from UK, Greece, and Spain, and we'll discuss the challenges of competition policy at national level. And Makis Kominos, a former member of this group, will chair this session. 2 sessions organized by our partners will follow. The first one is managed by Osborne and Clark, and will address the design and implementation of antitrust compliance programs. The second one is managed by DG Comp, and we'll talk about the retrospective analysis of competition policy. And they will end with a debate moderated by Jeremy Fleming-Jones of our media partner PAR, between the DG Comp Director General Olivier Verson and Andreas Schwab, Internal Markets Committee Rapporteur of the European Parliament. Finally, on Friday, we will start with a session organized together with the OECD, the EBRD, and UNCTAD. And this session will explore the work that these and other organizations do to help young or less experienced competition agency foster their competition policy. And the session will be chaired by Lorenzo Ciari of the World Bank. Then there will be 2 sessions organized by our partners. The first one is managed by Dentons, and will discuss settlement procedures. The second one is organized by Ulrich, and will talk about competition policy and life science, a subject that is definitely particularly relevant in the current situation. So we have a very dense program, and it's time to get started. So I'll invite the 4 panelists and the chair to switch on the webcam if they haven't done so yet. and I'll hand over to them. Alberto, the floor is yours. Let me just remind everybody that there is a Q&A function that you can find at the bottom of your screen. So if you want to ask questions to our panelists, you can do it through that function. Okay, that's it. Alberto, the floor is yours, and thank you everybody for being here.
Thank you, Paolo. Thank you very much indeed. And first of all, let me compliment you for your initiative. After a few very successful Lear conferences, now we have a Lear festival, and I've known you for many years now, and I'm always surprised by how ingenious and innovative you are. So many compliments for that. Also, let me thank you for having invited me to chair this initial section, and I'm extremely, and the more so because I'm honored to participate in to chair a panel of very, very illustrious participants. So here we are to discuss competition and inequality, and with us are Bruce Lyon, who is a professor at the University of West Anglia and has been one of the founders of the Center for Competition Policy of East Anglia. He is an industrial economist with a very long experience in competition and regulation, and he has contributed to the most important journals in the field, and also he has been an advisor to the Economic Advisory Group of the EU competition policy. So our second panelist is Daniel Crane, who is a professor of law, Frederick Ford Professor of Law at the University of Michigan Law School. He teaches contracts, antitrust, and antitrust intellectual property law. He has written extensively on these subjects. He is also of counsel for Paul Weiss. The third speaker is Deringer, and he teaches at Middlesex University, but he has previously taught at Harvard Law School and the European University Institute, and he is a frequent consulted by the European Parliament and Commission. Finally, we have Ian Fox. Last but not least, Ian Fox is just Ian Fox, so it is a legend in antitrust worldwide. It is somebody. She is professor of trade regulation in New York University School of Law. She has written extensively some of the most of the reference papers and books we use. She's known worldwide also because of the interest she has always shown on comparative antitrust law and the application of antitrust law in developing countries, and so she is very also interested in the issues of antitrust, social conditions, and inequality. The subject we are discussing today has been widely debated during the last decade, starting from basically three phenomena, which has been the intersection of three phenomena, 3 points, say. Obviously, over the last 20 years, income and wealth distribution has worsened, at least from the majority point of view in most industrial countries. This is not necessarily true if we look at globally, but it is in industrial countries. And this was due, obviously, to a number of factors which have little to do with competition, like fiscal policy, tax reduction, cuts in welfare budgets, technical changes, important, let's say, nearly technical revolutions, perhaps globalization, immigration flows. Nevertheless, in the same period, not only distribution, income and wealth distribution has worsened, but there has been also an increase in concentration in market powers in many countries. There have been a number of studies with respect to this. A recent OECD, obviously, many of you know the Philippine book on concentration in the United States and Europe. A recent OECD study has argued that there is a relation between income and wealth concentration and market power, and that reduction in market power could lead to improvement in income and wealth distribution. All these led a number of prominent, even not necessarily specialized in antitrust issues, economists to argue for actions by the competition authority in order to act on, to take measures or to act in such a way to allow an improvement in a reduction in market power and improvement in inequality. Even if this is not a central instrument, because there are many other instruments that are probably more suited to reduce inequality, nevertheless, this could be an important instrument. More recently, a number of prominent antitrust scholars like John Baker and Salop in the famous articles, and then others who have come after that, have suggested a number of steps that would be taken in the application of antitrust law in order to front the issue of inequality. Now, I think this is a little bit still have been too long. The background of the discussion we are having today, we have agreed with the panelists to structure the discussion in such a way that we will have a short, about 5 to 7 minutes presentation by each of them about their views. And then we'll have a discussion in a couple of rounds. Obviously, as Paolo said, if there are questions from the attendants, we will try to forward them to them. And obviously, the point then at the beginning is, what is your view on this? Can the application of competition law contribute to reducing inequality? Should competition authorities design their intervention on the basis of distributional clause? And if so, what would be the instrument? I would ask Eleanor to start the discussion there.
Thank you very much. Sorry, I was finding my unmute button. I'm very happy to be here. Thank you, Paolo, and thank you, Alberto. And also, that was a great introduction, and I'm going perhaps to repeat a little bit, because first of all, I think it's important for us to ask what is the problem? And then secondly, I'm going to make a claim that to the extent that competition law is related to the problem of the cure is very country specific. And I want to refer to the distance, for example, between South Africa and the United States. And then thirdly, what competition law can do. So what is the problem? There is an increasing gap, a growing gap in wealth and income, apparently all around the world. And what has caused the problem, as you have reflected on, Alberto, in my view, what has caused the problem? I didn't really finish. What is the problem? What difference does it make if there is a huge inequality gap? Well, there is a socio-economic, political problem if all the gains of transactions go to the very rich at the expense of the very poor. And to the extent this is happening, democracies are more fragile, conflicts are more likely, unrest is more likely, democracy is undermined. what has caused it is, in my view, and you've touched on this, Alberto, globalization and technological change have driven away the jobs of the unskilled and put more center stage the job of the very skilled, for which education is required. And at the same time, there seems to be immobility, not easy mobility from the bottom to the top. And when there is this poor mobility plus the sustained inequality, this all builds up to this huge social political problem. Technology is very key in my view. And to the extent competition law can do anything in closing that huge gap, I think it's questionable, as I will come to a little bit later. But at the same time, and here I'm coming to the point I want to make about the question is country specific, and country specific in the sense of, does the competition law value equality or not? And in my view, a great number of countries that have competition law have valued equality in some sense when the legislature has passed the law. It's sometimes said in terms of, we don't want the powerful few and the privileged to be ruling economically. We want the people to have their fair share, and we want the people to have sovereignty, and we want the people to have mobility and opportunity to contest markets. A number of countries have incorporated this view. US did until about 1980 and does no longer, and is more on the neoliberal track. South Africa, when it adopted its competition law, adopted it in the name of greater equality. And just to say a couple of specifics about South Africa, which really make it distinct in terms of equality. When apartheid fell, the new constitution was adopted. The biggest values protected by the constitution are equality and dignity. And they had much to think about in terms of how they would adopt their competition law. But one thing was relatively clear and has become clearer, that the structure of the economy, which was all white owned, was very stable and hard to break through, and in some sense almost exclusionary by its nature, although they hoped that having competition law would open up the markets and make these markets contestable by the huge left out majority. And even now, and more recently, they've adopted amendments in the name of greater equality, which I view as using competition law as affirmative action. And this may be problematic in terms of the trade-offs to efficiency and efficient business, but this is what they have chosen. So let me just go on to say, because time is short now, what can competition law do? And it can depend upon where the country stands, both in terms of how much it values equality and also in terms of the state of its enforcement and whether it has been under enforcing competition law. So here I would offer US as an example, given our Supreme Court jurisprudence of way under enforcement of competition law in the name of freedom of even the dominant firm to do what it can on the theory that it is likely to do what is good for the consumer. In my view, if one is equality conscious, there's a lot of room to move, even in an efficiency and consumer welfare paradigm that brings in or nods to more inclusiveness, more attention to lower barriers, contestability of markets, so that one role the equality notion can play is to give us the consciousness of saying, we can do more for openness and entry of markets, which tends to equate more to equality without sacrificing efficiency, and ought to do so. A second thing that competition law can do is the following. In my view, using Calder-Hicks and aggregate consumer welfare and saying, we always say, we learn everyone's better off if aggregate consumer welfare is up. And of course, it's not true because there are losers as well as winners. And I think that we ought to be on a track of breaking out who are the winners and losers, both from enforcement and from non-enforcement. And authorities could make some better, meaning more sympathetic to equality choices, if they realize whether, for example, from this enforcement, the rich will gain, or whether from this enforcement, poorer people are hurt, as perhaps in the US case against the trial lawyers representing indigent defendants, when there was a very difficult question as to whether the suit should be brought at all. It was brought, and it was brought, of course, with no regard to who were winners and losers. And then there's also, as I already mentioned, I mean, those are two ways. A third way is, my second way, incidentally, includes prioritization. But there are a lot of reasons why authorities want to prioritize. And the third way is what I mentioned for South Africa, which is putting your thumb on the scale to advantage people who have been left out, in the hopes that that is going to give a better distribution. Thanks.
Thank you, Eleanor. Really, that's what we expected of you. Very fascinating introduction to the subject. I would like to go to Daniel Craig, to give his view, which I expect a little different from what we have had. Daniel, the floor is yours.
Well, thank you, Alberto, and thank you, Paulo. It's a great honor to be with you, and I'm sorry we can't be in Rome. I'd love to be in Rome right now and seeing all of you in person, but thank you. And so I think I have been invited here to offer a bit of a contrarian point of view. So Eleanor and I are longstanding co-authors, and I agree with so much of what she said, but I will offer a point of it with a bit of a difference in emphasis. I just want to say, in terms of my own normative priors, I would be less inclined to concern myself with equality than with absolute conditions. So, of course, one way to make everything equal is to make everyone poor. And there are policies by governments, there are regimes historically and today in which that is largely true. And we have a large measure of equality, and we have abject poverty. And I don't think that's an attractive normative view for what we want a system to accomplish. So in my view, we should certainly be attentive to the absolute condition of people in the lower income strata, and to the extent that there is impairment of their condition, that should be a focus of policy across the board. I would just say that my own prior is not to be as concerned about equality as about absolute conditions. Now, having said that, I want to sort of play within the paradigm of competition law and equality and ask the question, is it generalizable that increasing competition enforcement increases the progressive distribution of wealth? And I will suggest that although I think there are, of course, particular ways in which competition policy may increase the progressive distribution of wealth, that's not generalizable. I think, and to the extent that we've heard people say in the last few years that sort of we need to ratchet up the level of competition policy so that we get more progressive wealth distribution, I think that's wrong. I think that's just too general a claim to be sustainable. So if you think about competition enforcement and the distribution of wealth, there are sort of two factors you need to keep in mind. One is who pays the rents when there are monopoly overcharges, who pays for that? Another one is who obtains or who gains the rents. Both of those things are conducive to understanding the distribution effects. So I think what the conventional story we often hear is one of wealthy shareholders and poorer, relatively poor consumers. So shareholders as a class are relatively richer than consumers as a class, although of course there's overlap. And therefore, when market power increases, shareholders obtain more money at the expense of consumers, and that increases wealth inequality. And again, I do not doubt that there is truth to that story. I just want to say it's hard to generalize that to more competition enforcement is good for wealth inequality reduction. So first of all, on the question of who pays for monopoly rents, is it really the case that consumers as a class are the ones who generally pay, or poorer consumers pay for monopoly rents? We can give examples of luxury goods where it's sort of idiosyncratic, and it's rich consumers maybe paying money to sort of poor shareholders or producers. But even beyond that, in terms of sort of big systemic things to think about, just think about the fact that up to of the entire economy in most industrialized countries is accounted for by government spending, government purchases from markets. Think about defense, think about much of healthcare, think about much of education, think about much of infrastructure. There's an awful lot of just spending that purchasing from private firms that or from labor markets, that is government spending. Now think about what happens if there is an anti-competitive condition in the supply to the government for this up to 1/4 of the market. Well, how that gets born in terms of progressive or regressive effects depends upon the tax system. If you have a progressive tax system, which most industrialized countries do, that means that an increase in the prices charged to the government is borne by taxpayers on a progressive basis. Not to say that in the immediate short run that wealth inequality necessarily changes, but the conventional assumption is that taxpayers are the real party payors of government spending. And to the extent you have progressive taxation, the implication is that actually antitrust enforcement that lowers the monopoly overcharges is actually regressive in this sense. So there are other examples on the who pays side, but this is just one large illustration of why it's dangerous to say that more antitrust enforcement quickly leads to a more just distribution of wealth. The other side of the coin is the second question, which is, well, who pays? Who receives the monopoly rents? Is it shareholders? The interesting thing is that a conventional assumption of competition policy is that monopoly rents often do not show up on corporate balance sheets because they are internally consumed within the corporation. I think here of Judge Learned Hand in the famous Alcoa decision, explaining why it is that Alcoa may not show large corporate profits on its balance sheets and yet still be a monopolist, right? And we can think of many cases like this where the defense, well, look, I'm not making an abnormal rate of return on capital. It is not at all a defense to someone being a monopolist, because within the black box of the production side, the rents can be dispersed in many ways. Why is it that many anti-competitive mergers are supported by labor unions? I think, for example, of the AT&T T-Mobile merger that was ultimately defeated in the United States, that was heavily supported by the Telecommunications Workers Union for 3 million people, right? Now, there's a long story there about AT&T's corporate culture being better than T-Mobile's corporate culture, but clearly the union thought that the merger, which was an anti-competitive merger, was good for the interest of the working people represented by the union, right? So again, I think if we start relaxing the assumption that monopoly rents tend to be captured by shareholders as opposed to distributed to lots of different interests within the producer black box, then it becomes much more challenging to generalize the case that more competition law enforcement leads to a reduction in wealth inequality. And the last point I want to make, and I think this is very sympathetic to the point that Eleanor made, is that it is clear in my mind, at least, that there are instances when competition enforcement directly reduces opportunity or wealth equality. I'll give another example, which is education, a case brought in the United States successfully against the Ivy League colleges and universities for basically coordinating financial aid to students. And at least in the view of these universities, the reason they wanted to coordinate financial aid was to disperse opportunity and money more broadly on the basis of need and diversity, as opposed to simply allocating scarce financial aid resources to the most privileged and best performing students. Now, that could be right, that could be wrong. But when that system was broken down by antitrust challenges, arguably at least, the effect was impairing the opportunity of schools to work towards solving a social problem of inequality, right? And so in my mind, at least, to the extent we want to say that inequality needs to be a focus, a criterion in competition law enforcement, that needs to operate in both directions, which is there's circumstances where there may be a justification to bring a case, but there are also circumstances when that may be a justification not to bring a case. And to generalize that we just need more competition law enforcement to reduce inequality, I think would be an unsustainable proposition. Thank you.
Thank you very much. Thank you very much, Daniel. That was extremely interesting also because it's a different view. It also shows how views change over time. There was one argument with respect to shareholders where in any case, many of the shareholders are held, for instance, in pension funds. Therefore, the increase in the value of shareholding, after all, doesn't go necessarily to the few rich, but it goes to the population at large. Perhaps things have changed, so one must always consider how the things evolve. And in this context, I'm glad to give to Deringer Kovacic the floor. He has, in addition to his academic position, he has worked extensively on the issues of inequality, institutions, and periphery, relations with the center of periphery. So I think it will give us some new light. Thank you very much. Deringer, please, the floor is yours.
Yes, thank you so much, Alberto. Thank you, Paolo. Thank you, everyone. I'm delighted to be here. Thank you for organizing this fabulous event. I also wish we could be in Rome. So
the weather is very good here.
Yeah, so possibly next time. So first of all, I definitely agree with Daniel. Actually, we discussed this about 5 years ago in the wonderful premises you have there in the background, Daniel. So really, I think we are on the same page, particularly on the first part of Daniel's discussion, which is, this sweeping general assumption that more existing competition law enforcement brings more equality just does not hold water, right? I mean, the analysis is much, much more complex, and competition law was not created to create, was not conceived, from the outset to attain more equality in society, right? The goals are simply different. So the idea that, consumer welfare and low prices will bring about more equality is just not borne out by the analysis, because the question really is who's really accumulating power in these activities on the market, even if the low price is actually produced in a competitive market, right? So not in a monopolized market, but a competitive market. So who's actually accumulating power? So, I mean, as you mentioned, Alberto, I did a lot of specific work in regional inequality in the European Union. And in the center periphery discussion, the low prices that the periphery consumers are enjoying because the corporations of the center are able to segregate markets and offer them low prices actually don't contribute to the equality, because those consumers are also workers, and those workers are losing jobs because the center companies have the privilege to drive the competitors from the periphery out of the market. So there's many ripple effects from, in society, from this very limited analysis of antitrust competition law, in which the interests of the market power is pitched against the consumers. And if we don't take those ripple effects into consideration, the analysis simply it just becomes very unclear, and it becomes very clear that competition law in itself, as it is conceived now, cannot automatically contribute to more equality. Also, if you see, let's say, for fighting market power, I mean, there's unprivileged corporations in the market just as well, and how do we take their interests into consideration, their workers and their shareholders? So it's a very complex analysis that needs to be done. But then again, at the same time, so I would really reject this assumption, but I would also reject a general assumption that more fairness, in abstract, would bring about more equality, because one can, hide many things in the language of fairness and morality and justice, and those do not necessarily. I've seen many, legislative proposals and legislation which was based on fairness and justice, and it just can bring about inequity just as well. So I think what we need is really an independent ethical analysis. We need to identify the consequences of the sort of standard efficiency analysis and of the fairness analysis. So what I would really put on the table here, and I think a God is in the detail, right? So we have to make a detailed analysis of one and the other before we proceed, and also in a particular jurisdiction, as Eleanor mentioned. Now, so I think it's really important that we have some sort of a grid or an idea of what we want to equalize at all, right? This is, I think, is very important. I think Daniel puts on the table sort of a Rawlsian, if I understood correctly, idea that we have to benefit the least, the people who are least, who are worst off in society, but he would not equalize. I think his goal is not to make a claim of generally more equality, if I understood correctly. But I mean, what is important is that we have a clear idea of a grid, what we want to equalize. So I did specific work in the center periphery relationship structure, but what is really important is this grid is precisely articulated so we know what we're actually doing on the market. Now, Eleanor mentioned, and I agree with her here, one really needs to tackle the issue in a particular jurisdiction. And in South Africa, this might be easier this grid or structure might be easier to identify because there's extreme poverty, there's a historically disadvantaged group. In the European Union, which is much more equalized, this would be possibly more difficult to articulate. But I think it's important, again, I would like to emphasize, unless the debate becomes quite vague, that in a particular jurisdiction, it is clear what the aim is, what we're equalizing. So why is this? This is important so that the administration can actually know what it's doing. It's important intellectually because I think we need to devise new theories of harm. So basically because we have some theories of harm, but obviously I think we know today they're not sufficient. Even if we go beyond the antitrust and inequality discussion. And it is difficult to devise new theories of harm and to articulate new doctrines and instruments to fight inequality that we would want to address in a particular society if we don't have such a grid or structure. So it's important on an analytical, intellectual level, but it's also important on the level of enforcement, because there's an institutional problem. I mean, obviously courts, competition authorities, they need to have some sort of a clear mandate. The judicial review is not possible if all the criteria are very vague. So there's problems with, separation of powers, critique that could be, obviously, basically directed at make proposals. So in the European Union, there's an added complication of national enforcement, decentralized enforcement, and you need some sort of a unity, you need clarity. Courts need clarity, competition authorities need clarity. But this, of course, so this is an institutional problem, and you would need some sort of a consensus, a political consensus in a society on what we want to equalize. This may not be easy to attain. So in the European Union, this would be, the discussions about it would be akin to discussions on the EU budget, which are always very difficult. So how do you distribute in a society? As I said before, in South Africa, this might be clear because of a clear disadvantaged group there. So that's why I doubt whether sort of a wide-ranging redistribution is really imminent in the European Union. So I'm focusing on the EU, where I've done most work. But I think these are also quite existential questions, for the long-term stability of a society. For inclusiveness in a society. So I think these are very important questions, in fact. But unless we have some sort of a clear idea, some sort of a clear grid in mind, so what we want to do, the debate will stay more on the margins, which is fine as well, if that is our preference. But and then if debate is limited to the margins, basically it's questionable if this is not where intellectual and political change is most needed. I would say, we would possibly need a much more deeper overhaul of antitrust, subject to limitations in particular jurisdictions, of course, and to the political consensus and so on. So basically this is how to conclude. So I think it's a really fundamental discussion. but God is in the detail. This is really my message, right? So no automatic, more competition law, no automatic, more fairness, but really there's a lot of analytical work to be done, you know, from lawyers and economists, I think, to bring this discussion fruitfully forward. Thank you.
Thank you, Dr. Jan. There are a lot of things which have been said and would raise questions. And so now we have Bruce, which may tackle some of these and perhaps give us some, tell us how to deal with the details then. Bruce, the floor is yours.
Okay, thank you, Alberto. I think there's it's very interesting the range of views, but there's a great similarity, but it's a matter of some important nuances here. So I start from the position that there's too much inequality, both within jurisdictions and across the world. And we should work towards improving the equality of opportunity, which is often tied to wealth. Now, here I could go off with a great debate with Dan, I'm sure, about some of these things, but that's not what this debate is about. We have to tackle the question of should distributional goals affect competition policy in the way that it's designed and enforced. And there, I think this narrower focus, we get to some points of considerable convergence and perhaps more modest divergence. So I want to make 3 points. Point number one, expert competition authorities should pursue competition goals and not have a primary duty to weigh competition and distribution. Now, fortunately, I think that more competition and greater equality tend to pull together. So trade-offs are not prevalent. I think monopoly profits disproportionately accrue to the rich, and if competition policy reduces market power, then generally speaking, that's a good thing. But as both Eleanor and Dan have all pointed out, it is not that straightforward. And in particular, when you think of things rather more globally, globalization has been a major competitive force in recent days. It's really raised inequality within developed countries in particular by affecting incomes at both ends of the scale. Others have already mentioned the competitive impact on unskilled work, and especially in those sectors which were previously fairly monopolized and where workers could get a share of the gains which are then eroded by foreign competition. So allowed huge opportunities at the top of the income distribution scale, a fact that was noticed by Alfred Marshall back in the 19th century about wider communications, globalization means that those with slightly better products or slightly better talents are able to get huge increases in the rewards. And so we see some real global billionaires emerging. So, nevertheless, where we shouldn't go is to say that weaker competition policy is the answer. It's not the answer. We take as realistic the effects of competition on income distribution. It is ambiguous. I'm a bit more optimistic than some of the others on the panel. That I think, generally speaking, we do want more competition policy, but it is not, or competition enforcement is not the answer. Now, I do see two nuances to distribution in relation to competition policy in its operation. So the first one, which is my second point, is that resource-constrained competition authorities should use as part of their case prioritization where that's possible. So suppose a competition authority becomes suspicious of the possible existence of two quite separate cartels, one in a city's bread market and the other between elite private schools. Now, the first best, I still think, would be to investigate and prosecute both cartels. But realistically, competition authorities are resource constrained, so they have to choose. Now, if the bread companies are multinationals and selling the staple product in the cities, and if the elite private schools are educating the sons and daughters of internet bankers and oligarchs, then we might see a fairly straightforward mapping of into, well, we should prioritize the bread cartel investigation over the elite private schools. But actually, even that is not always straightforward, because a bread cartel may be between small artisan bakers struggling and selling into a rich part of town. And it may be that charities are funding scholarships of poor children to promote the mobility that Eleanor is so concerned about. The cartel is diluting their funds for educating the poor. So these things are certainly not straightforward. Nevertheless, I still draw the conclusion that we can do certain things. I do think that keeping a focus on consumer welfare is one of the things we need to do, rather than taking a particular view on the profits of firms. I think that we should ensure that competition authorities are well funded, because then we have fewer of these difficult trade-offs, even if it's not going to be a huge, or it's a serious solution to distributional issues. And thirdly, I think we should accept distribution as an input into prioritization of cases in resource-constrained authorities. Now, the third and final point that I want to make is, I don't think has come up, and that is that there are recent trends, people often label this to do with digital, have brought huge new opportunities for price discrimination in consumer markets. And I think that competition authorities, competition law, can have a role in protecting the poor against some part of that. And they need to be very clear on that. So many products we previously purchased as one-offs are now sold as services. We used to buy a CD for our music, now we rent it through streaming services. It's long been understood that price discrimination is easier for services than for goods which are subject to arbitrage. So this servicization, as I call it, opens up the opportunities for price discrimination. There are other forces at work. There's been the shift towards more default direct debit, they call it in the UK, payments for goods on a continuing basis. There are and auto renewal of service contracts, and there's a lot more data out there, so that firms can, in principle, use individual characteristics for personalization. It's debatable how much is going on out there at the moment, but certain aspects are coming in. So I think that price discrimination is a a big and growing issue, and many aspects of it are perceived as unfair. Now, I think it's really important to distinguish what I call transactional unfairness from distributional unfairness. And by transactional unfairness, which is something I've been working on with Bob Sugden, are practices that are deceptive or hinder consumer choice, regardless of their distributional impact. Whereas distributional fairness and unfairness is this more macroeconomic concept. You know, it's about the person rather than the transaction, and the transactions are the ones which we tend to focus on in competition. So where does this take us with price discrimination and the poor? Well, firstly, an awful lot of price discrimination is likely to favor the poor. They have lower ability to pay and more elastic demands, whereas wealthier people it's easier to charge a higher price to very often. But on the other hand, the wealthy may have a wider set of opportunities to choose from, so they haven't got to buy from the local shop. You know, they can do it, get from wherever they want. And also they may be more sophisticated in understanding some of the pricing practices that go on, which are prone to unfairness of some sort. I leave that very open. So I add to that thought the thought that very often price discrimination is pro-competitive. It encourages firms to tackle a rival's strong market and vice versa, and so it's generally pro-competitive. So if the price discrimination is working in favor of the poor and against the rich, and it's making the market more competitive, so generally prices are coming down, fantastic, don't touch it. On the other hand, in those, I'd say, relatively few cases whereby we observe that the poor end up paying more than the wealthy, then I think it would leave room for a sort of a modest new duty for competition authorities to tackle price discrimination that works against the poor. So in conclusion, where my view is that distributional issues can and should operate only at the margins of competition policy, and the two examples I've given there are in prioritization and in a very limited and focused concern for price discrimination that harms the poor.
Thank you very much, Bruce. Thank you very much, everybody. Now, we have about half an hour left, and I wanted to take some suggestions in terms of new discussion, suppose you on tackling inequality and competition from a different point of view, which a little bit from the point of view which, one of the points of view which Ian was suggested at the beginning, and which is a little bit referred, also related to transactional unfairness you were mentioning. Because we can see inequality in terms of income distribution, we want to help the poor and so on. Or we can think of inequality, inequality in a different distribution in a different way. Seems to me, as Ian was saying, that at the basis of competition law in many countries, surely many European countries, I would say even in the EU, there is the idea that a competitive market system is an inclusive system, a system which allows people to improve their position by participating in the economic activities and improving themselves and getting opportunities. And I think that a lot of the preoccupation which has come out in the last decades comes from the perception that this process of upward mobility, let's call it, is a little bit stopped. So now, getting from there to transactional unfairness and competition, application of competition law, I was wondering whether this is not also related to the path competition law has taken during the last 20 years, 25 years, with the triumph of the Chicago School. And I think there are a lot of very good things in Chicago School, no antitrust law. There are a lot of good things in the more economic approach, but still that mobility implies an attention to barriers to entry, the comparative process, and so on, which perhaps we have a little bit put behind with the idea that what matters is finally consumer welfare. And this may have led us to undervalue the comparative process or the barriers to entry, and therefore brought us to say to be more worried about false negatives than about false positives, for instance, when we examine cases. So I was wondering that what do you think, and I will start with Daniel first.
So it's an interesting question, and obviously I'm all for more mobility of people and goods. The difficulty I have is knowing when a particular antitrust intervention actually creates more mobility. So let's take the example of Amazon, which obviously is under immense antitrust scrutiny right now, has immense market power, and has put out of business many competitive retailers in the world. Is Amazon's market power, its position in the world, good or bad for opportunity and mobility? At the primary level, it seems bad, right? It's knocked out of business many competitors, but it's also created an ecosystem where anyone can sell anything anywhere. I mean, you think about the number of very small businesses who now can access customers anywhere through the Amazon marketplace. Or book publishing, right? Book publishing used to be very difficult. You had to go through one of the 7 big book publishers to get a book published. And today, I mean, anyone can publish anything on Amazon and get instant distribution. So at some level, Amazon, by being this sort of behemoth at the retail level, has clearly created more opportunities and more mobility for people downstream. So what's the net effect on mobility, right? So I don't know how to answer that question. I'm not sure I know how to answer the conventional consumer welfare question, but at least I think I understand what it points me to in terms of analysis. I'm not sure I know how to answer the question, is Amazon overall better or worse for mobility and opportunity of people and services, who otherwise may not have had the same access that they have today? So I guess my bottom line is, it's an attractive idea. I'm not sure I know how to operationalize it.
Thank you, Daniel. Eleanor, what's your point? What's your views?
Right. So my view is a little different, Dan. My view is the approach to the problem is a little different. So first, just on mobility, but I want to say a word about fairness too. On mobility, I would always want to focus on what is the conduct that one is complaining about. And often, if you're thinking about mobility, you're thinking about the opportunity of the outsiders to pierce a market. If you're confining it to our traditional antitrust concepts. So I would think a lot of dominant firm strategies that have a dominant effect of excluding outsiders should be on the screen here. And the fact that they're excluding outsiders should be given more weight than, for example, US antitrust law does today. That's the extent to, that's how I see it. The mobility means people ought to be able to enter markets and contest markets on their merits, and they might have to be big enough to do it. But if you focus on that as an important input to the antitrust analysis, you would be getting more mobility. A word on fairness too. I think if you focus in on problems, you could make it operational, but you need to have the context. So for example, with the big gatekeepers today, the gatekeepers, I'm talking big data, top GAFA, top 4. So they have their own platforms. They've promoted the platforms as places that business can do business, and that's given people lots of opportunity. But then they snap at their rivals and cut them off at the knees when they think the rivals are doing too well and might be good competitors against them. For example, Facebook did this with Vine, and there are examples on almost every one. It's a more serious than preferencing. I'm leaving preferencing alone for a minute because preferencing is almost, doesn't have the impact as when there's the sabotaging of the rival. So a question which comes up legitimately is, well, does the platforms made the platform, and do they have the right to do whatever they want on their platform? That's one way to look at it. And another way is they've made the platform, and in these handful of cases, that platform has become something like, I'm getting into dangerous territory, a central facility where they're opening it for people to compete on the merits, and then they're turning on them. Maybe there are fairness obligations, even if you can't prove that that sabotage of the rival is going to lessen output and hurt consumer welfare. I think there is, related to this, a legitimacy point. This is a bigger and different sort of overarching thought. If we were to say, we were all to agree, no, equality is not relevant to antitrust, forget about it. Fairness is not relevant, forget about it. The more we do that, we are the technicians who operate apart from what any of the non-experts can see, and antitrust looks illegitimate.
Very interesting indeed. So views, how do you say that this very well structured defense of
the term fairness in association with competition policy is it's over flexible. People use it in very different ways. The argument now has drifted towards fairness to small up and coming firms who maybe want to sell out to become multimillionaires, if not billionaires. Right? It's a fair competition type thought. It's nothing to do with the personal distribution of income. It's nothing to do with the poor. It's about another topic. It's an important topic, the whole digital competition point, but I don't see that as our focus here. I don't think that it's you know, poor people who come up with a brilliant idea and then get blocked by Google. I mean, you know, I think an awful lot of the poor can, as Dan suggested, you use Amazon to pull themselves up, and I think that's a positive thing. I want to look at Margarita Vestager's speeches. Looked at them for the last year or so, but she was talking an awful lot about fairness at the time, and I was interested in this transactional fairness thing, and I was saying, oh, thinking, great, you know, she's talking about. She never once talked about fairness to consumers. It was all about fairness of big firms to their potential rivals. And I see that as central to competition policy, but I don't see that as what I'd call a distributional issue. So there's my first thought on that. I mean, there's another thought, because it's a quite different one. But Alberto, you mentioned the last 25 years of sort of a change of competition policy. Go back to the origins of it. I mean, I bow to Eleanor and Dan for the Americans and trust busting and things. And I know there are complex issues there. But if we take it up to the 20th century, and when across Europe after the Second World War, we managed to started to get things going. In the UK, it was all about moving from a wartime economy where planning seemed to have been working towards the post-war economy, but everything was about public interest. So the Monopolies Commission looked at public interest. It wasn't specific to competition. The people who were on the on the Monopolies Commission would include a whole range of trade unionists and industrialists, but the great and the good, as it were. If you look at Germany, then again post-war, heavily influenced by the fact that large firms had gone into cahoots with the Nazi regime, and an absolute determination never to go there again, and to therefore want to protect an idea of a diverse, small and Mittelstand type range of people. You could go on. Every country had its own different views, but then through the 80s, 90s, there became a convergence on competition. You can characterize it as the Chicago view, and that was very, very influential, but we then moved on towards post-Chicago. We've also got the European Union and the crumbling of the Eastern Bloc, and new countries wanting to join the EU. They were having to get their competition policy simply with a motive to join the EU. We see around the globe the role of the IMF and the World Bank and OECD, but there's a whole diversity of views, but these were becoming congruent around the turn of the century. And that view of focus on competition and moving away from political decision-making towards independent experts, role of economics, led to this enormous convergence up until, of course, the financial crisis shook the faith in competitive markets, and there have been various challenges since. So it's rather a long-winded answer, but I'm trying to get at is that there's a whole range of things, but the institutions have tended to develop towards going towards expert decision-making, which is very good for looking at competition and the effects of competition. But in terms of weighing, if there was to be any weighing of that against distributional issues, that's immediately a political decision. So simply the political economy of institutions, to me, means you want to keep those as separate as possible. But I've gone on rather lengthily, so I'll give others a chance to come in.
Yeah, can I say something? Yeah,
yeah,
can you hear me?
Absolutely, please.
Okay, okay, great. Okay, thank you so much. So first of all, I mean, just a quick comment on, fairness discussion that I actually touched on already, but I don't think it is possible to separate this rational choice economic analysis based on self-interest from, the discussion of justice and morality. I think these discussions are always intertwined, particularly because even if we're taking the self-interest based analysis, the efficiency, it's loaded with normative assumptions. And I think these discussions just cannot be separate. There's always a connection between them. So I think that's quite important for this discussion, I think. And also distribution is always there. So antitrust always distributes. The question is just the distribution, as it is now, or do you want to change it? I think that's the key question, right? But about upward mobility that you ask about, I think this is brilliant, because very frankly, the way I approached the discussion between competition law and inequality was more about, is competition law, preventing upward mobility, let's say in the periphery of the European Union, so how can these poor countries lift themselves up, on the internal market? So I think this is quite the key of this entire debate, upward mobility, more than, the society generally is unjust and let's just equalize everything, sounds, I think, exaggerated, or brings back, the ideas of Marx, which were not used very well in practice around the world. So I think upward mobility should be much more of a discussion, and frankly, it has really affected my approach to this debate, and I've written about it. I haven't mentioned it today. Now, but your question, I think, also touches upon this eternal debate between, if I understood correctly, between the European, let's say the United States being more focused on consumer interests and consumer welfare, and maybe the EU legal system being more based on the ordoliberal idea of, we have to protect the competition itself as well, not just the consumer. So this is, it's a never-ending debate, and it seems that the European Union is tilted more towards the ordoliberal ideal, definitely, than the United States. However, at the same time, I'm not sure, again, the God is in the detail, the devil is in the detail, depends on how you want to see it. Again, it depends on a particular case, as to how these concepts will be used. I think this has something to do with my general view of things, that if we change antitrust or competition law in totality, infuse it with morality, we don't know what this is going to produce in terms of distribution and fairness. So we have to be really, really detailed as to what we're talking about. But also one thing I want to add, so it seems to me that going back to this distinction, consumer welfare or the liberal process of competition, focusing on the barriers to market, focusing, who can enter, who can compete, because we need competition on the merits. That's the point of competition law, right? The problem is that, is it really the way we are analyzing now? Is it really on the merits or not? And these are huge questions. Let's say now, the new Commission's proposal on the regulation of gatekeepers, on ex-ante control of gatekeepers, let's say Apple would have to give access, let's say, okay, let's say to Spotify. Okay, we have a Commission decision on that, and let's see what happens with it before the court. But there's a, there's a new proposal in which gatekeepers such as Google or Amazon or Apple and others will face certain obligations. So how they actually foreclose the market, how do they block access, even if there's no anti-competitive effects proven. So this is, I think, quite amazing, and I think this sort of shows the development in the European Union, sort of more in the direction of the ordoliberal regime even further. But then, yet again, I concur with Daniel again on this point, as I always do, that this is really so case specific. He explained this in the case of Amazon. So I think the future here is really, as I said, intellectual work. There's so much to be done, but also really deliberation, no grand changes, but really casuistic work, deliberation. That's where I see a lot of movement in the future, although not necessarily right now. As I think, as Bruce said, it should be more on the margins. I think this is the short-term development, definitely in the European Union, but probably also elsewhere. Let's say already now the Commission has a mandate to take this kind of considerations into account under 1013 or under the merger regulation. It can take the goals of Article 3 of the treaty into account, but it's not doing it because it's the political mandate is questionable. So I think this is where the at the very beginning, I think the developments will happen. So long term, it's more difficult to say. But then again, it seems to me, following also what Bruce said earlier, so the Commission, for example, already is taking some public considerations into account, and the court has totally validated them, like in Wouters or Mika Medina, let's say, on doping, and so there are developments that, although there were ancillary restraints, that show into the direction that these considerations will be taken into account more and more. At the beginning, more at the margins, possibly long term, going much more into the heart of competition law.
Thank you, Damian. We have 6 minutes left, so it's a very short time. I have just a couple of considerations on the use. Obviously, competition is not about distribution, and it's obviously its intervention is marginal at most. Still, discussion we were having about open markets and access and so on is something which is not irrelevant to at least the social view of social justification of the society. In the sense, just one point, and then I would like to have 1 minute of reaction from you on this. Iliano was mentioning the essential facility. Now, in Europe, we have special responsibility of the dominant company, essential facility, and then this goes into all the things Damian was mentioning the last few minutes about the tendency in Europe. It is a little bit a reflection of an idea which is behind of fairness in conduct, which is seems to me to underpin European views, even in the context of the application of the more economic approach. So let's go for a minute discussion, for a minute comment for closing the session. Bruce, what have you learned from all this discussion?
Right. Well, there has been quite a lot. I mean, what I think there is a general consensus on is that whatever our views on income distribution of wealth, competition policy is not the answer. So the question is, does that mean it has nothing to do with it? Or are there certain nuances there? And I think that Eleanor's point on South Africa and sort of needing to be able to get the businesses of non-white businesses in there and competing, there is a problem with that, because we know that if you try a sort of reverse discrimination or something, that can lead to monopolies created by one group shifted to another group, and it's not really helping on the distributional goals. But I'd be interested to hear from her in more detail whether she thinks that actually competition policy as implemented in South Africa has been beneficial, and whether there are negative things. In terms of what Dan said, I mean, I thought it was very clear, very sharp critique of the naivety that many commentators have in terms of thinking about competition and distribution. As you have picked up, I don't agree with exactly where he gets to on this. I think there are some modest things that can be done. And from Deringer, I particularly picked up on the point he makes about judicial review. And if you're talking about competition in a legal context, and if you are to introduce anything beyond straightforward competition concerns into that, they need to be stated very clearly so that the judicial process can proceed appropriately.
what are your closing remarks?
Daniel.
Oh, okay, me, thank you, yes. So very briefly, this has been a very interesting conversation. I think there's lots of convergence in our comments. I guess, not to really walk back my initial comments, but the subject of democracy has also come up. I mean, Bruce mentioned the role of concentration and fascism, which is something I've spent a lot of time on the last several years. And Eleanor and Damian have also sort of mentioned the ways in which there are correspondences between competition law and democracy and equality questions. And I very much think that's true. One of the things I think, though, is if we put too many explicit goals onto competition authorities, they may end up achieving none of them. So, but if we pursue a economically informed competition policy in a vigorous way, I think there will be positive effects for democracy, for the absolute well-being of the poor, and for equality overall. So maybe this is to say, and I agree with Eleanor, this is action specific, but at least in industrialized countries overall, I think pursuing a competition law focused on economic efficiency, consumer welfare, maybe competitive process, whatever it is. But I think that kind of a focus does have positive spillover effects for other things that we should care about, like equality and democracy as well.
Thank you very much, Daniel. Very good. Damian, do you have anything to add to what you have said already?
Yes, well, thank you. Just very briefly, I'm afraid I didn't hear Daniel well because my internet connection seems to be bad. But what I just want to say is I think competition policy is, I hope you can hear me, guys.
Yes.
That competition policy, very good. Competition policy is a part of the answer and needs to be studied in depth. It creates a lot of distribution. It is a part of an important analytical toolkit that we can use to make societies more inclusive, more just. And I think this is important. In the European Union, this is also very important for its stability, for its long-term viability. So competition policy is a part of the answer, but of course, this creates many problems, you know, the majoritarian problems. So how do you define what we want to achieve? You know, so the judicial review issues, you know, how it can be precise enough so that, you know, courts can review this, or will courts just defer, you know, to the rational legislator? So many questions here, but I think it is really an important debate for the future, not just of competition law, but, you know, of law in general. Thank you.
Eleanor,
Thank you.
You'll conclude.
All right, very quickly. No one is, in my view, trying to equalize anything. I think the question that's been posed to the competition community is not a question that we answer easily. And we want to focus on different things. Like I really want to focus on lifting up the poor, as Daniel does and Bruce does. I think Damian does. Rather than focus on handicapping the very rich. Handicapping the very rich would help close the inequality gap. We're not really about helping close the inequality gap, but we are about thinking of how a good competition system can work. And I think in terms of my own framework, the good competition does work better as competition when it has an eye to inclusiveness, which is an equality consciousness.
I do thank you very much, Eleanor, for closing. I thank all of you for a very interesting, deep, wide-ranging debate. I hope the audience found it as interesting as I found it. I thank you, Lear and Paolo in particular, for giving us the opportunity to be here. We are nearly on time, so it's a big success. Thank you.
Okay, thank you very much. Thank you very much, Alberto, Damian, Bruce, Dan, and Eleanor for this very interesting discussion. I invite you to stay here if you have time and if you want to for the other sessions. I just want to point out that there is a question in the QA box for Bruce. If you want to answer in writing,
I'm just typing it in now.
Okay, very good. All right, so we can move to the next session. I noticed that even though we were talking about sort of old-fashioned issues such as income distribution, we ended up talking about digital markets. This seems quite inevitable today, and I'm very pleased, therefore, to have a session that is managed by Freshfields, Bruckhaus, and Deringer that will take up this topic specifically. So I want to invite Gianluca, who's here, okay, team, and Melinda. You already have your webcam on, very good. So Gianluca, the floor is yours.
Grazie Paolo, many thanks to Lear and to Paolo for having us and for giving me the opportunity to moderate this very interesting and very current panel. There have been many panels around these subjects in the last year, in a year where the pandemic has led to a proliferation of webinars, and digital merger has been one of the top topics being debated. But I think it is nice to have an additional one, because I think by brainstorming and further thinking these issues through, possibly we may see sort of something more concrete than just debates. So just let me introduce the two speakers and discussants that will be part of this panel. We have Tim Lamb, Director of Competition and Regulation at Facebook. So he will certainly give us a perspective from one of the key players in this area. And also we have the pleasure to have Ermelinda Spinelli, my colleague and responsible for the Milan competition practice of Freshfields here in Italy. I'm Gianluca Zampa. I'm also a partner in the antitrust group at Freshfields. So I may just share the. Let me see. Give me a second. Which this is the one. Yeah. I hope that you can see the slide deck. Sorry, this was the original sequence. So we're going to have a panel which is structured in a discussion format, and we are going to talk about the following topics, and we will start from what is really the trigger of the entire debate, and whether there is how perceived is the underenforcement gap that is discussed, how real, and what are the various considerations around that. And there, Ermelinda will take the lead on that particular topic. We will then discuss what is the key element or the key factor that renders digital mergers particularly tricky, and is how you go about assessing the relevant counterfactual, and how you understand how a nascent competitor could really transform itself in a competitive threat. We will touch upon how to identify the theories of harm in such a forward-looking type of analysis. We will touch upon what is considered to be a startup kill zone, or the fact that in relation to certain areas, it is argued that sorry, I am just receiving a request to do. Sorry, is this better? Yeah. Okay, sorry for that. So we were, the fourth topic would be on whether there is a startup kill zone, meaning by that an area in which essentially there is less investments in financing and supporting startups, because they are likely to be caught by acquisitions of this type. And at the end, we try to address perceived, the solution to the perceived under-enforcement. Just a few words in general about the overall debate and how it is moving. We have seen that in order to try to address the various topics I just mentioned, we have seen that internationally there has been various attempts and from various angles to address the issues one way or the other, and we have seen a way in which essentially perceiving an enforcement gap in merger control. There's been the direction of Germany and Austria trying to capture smaller transactions by attributing a triggering value and triggering importance to the value of the transaction. So it's no longer relevant how big and how much turnover the target has, but the value becomes a critical element. Equally, we have seen an attempt to try to capture, not changing the threshold, but finding ways around the problem, and either by using the tool that in Europe is known as Article 22 referral as a way to address this potential gap, but also more, let's say, innovative initiatives like the one adopted by or attempted by the Italian Antitrust Authority, which is to try to develop also in Italy a US-style ex post review mechanism, in particular aimed at addressing transactions that fall below the relevant thresholds. Other ways that agencies around the globe have tried to address these issues is tried to reorganize internally and trying to develop more expertise. Some agencies have been thinking about considering the digital sector as a proper industrial sector, as opposed to what probably is correct, which is certain digital elements which will characterize to a higher or lower extent most of the sectors. And naturally, we in Europe in particular have seen a lot of discussions about the introduction of regulations that, while not aimed at addressing specifically the issue that we are going to debate today, naturally would have an impact also on that front, and probably would reduce the overall perceived unenforcement gap. And then other ways of addressing the points have been trying to be very innovative in developing theories of harms in an area where the initial difficulty is really to understand whether a particular concentration is horizontal or vertical or conglomerate or a combination of the three classic categories. And this in the context of an evolving business model with the introduction of the concept of ecosystems, and this is leading to a lot of creativity in this field, and creativity that has also benefited of ex post studies done by the FTC, by this very same host to this festival, which are very helpful readings as they give insights on the way in which an agency or whoever assesses a digital mergers may go about in order to understand what could be the problematic areas. And we have seen also more extreme attempts to try to address this, and with the reversal of the burden of proof, and at the same time the impact on what in Europe was the basis for the European merger control regulation, which was the merger privilege that would go about would essentially reflect the assumption that the merger in any case are different from cartels, because there is some efficiencies at least that justify them. And finally, naturally, what we have seen is actually not just an idea, but an actual fact in the US in relation to the action against Facebook in federal courts by the FTC. The use of a different tool, not merger control, but Article 102 in Europe, or the monopolization prohibition in the US, as a way to address the perceived enforcement gap, which is something which I think we will need to discuss more in this debate. So with this, I think we can start our discussion, and we will touch these topics. The format is a discussion. I will first start with asking a question to Melinda in relation to the first topic, and what can you tell us about this common theme of an alleged underenforcement in the digital space, Melinda? Is there a real problem or not?
Hi, Gianluca. Thanks. Thanks for your introduction, and indeed your question gives me the opportunity to look back and maybe set the scene for this dialogue, because essentially, probably until a couple of years ago, the leitmotif about perceived underenforcement was that too many transactions fell below the radar. I think I recall a statistic that was quoted on a number of events where, the likes of Apple, Alphabet, Facebook, and Amazon in a period of 5 years, I think they said, where they carried out approximately 200 M&A transactions, and only a handful were reviewed. So, the focus was very much about, oh, we need to do something about the threshold. And, building upon what you said, we've seen Austria, Germany, for instance, moving into transaction value-based thresholds, which actually funneled some referrals to the European Commission. And clearly, obviously, we are also seeing this very recent move from the European Commission about a new use of Article 22, even where no national competition authority has competence to review a given transaction. And again, something you mentioned earlier, we've seen an increased appetite for ex post review, both in countries such as the US, where it's always been the case that you're able to review ex post, but we've seen, indeed, for instance, the suggestion by the Italian antitrust authority to the government to consider the possibility for the authority to review in a time span of 6 months a transaction which wasn't reportable, provided that some thresholds are met. And in particular, I'm alluding to a 5 billion turnover, overall turnover of the parties concerned, which is certainly a very interesting move, which goes in a direction that we've seen other national authorities taking. So that's the first step. So, perceived underenforcement, too many deals falling under the radar, let's do something. And we've already seen the results of this sort of call to arms. But then I think what is probably even more interesting is about the fact that there has been a debate, and it's very much ongoing. Well, actually, now we can review a transaction, we're looking at it. Do we have the tools to make sure that nothing falls between the cracks? Because indeed, there's been a number of commentators saying, or also enforcers saying that, well, we've been too good, too benevolent vis-a-vis mergers. Actually, we need to take a harder look. And for instance, Andrea Coscelli said, well, but true, that's what we want to do, but we have the tools that we need. While, for instance, Margrethe Vestager, I think most recently, she had quite a more nuanced approach. You know, she did have a few declarations about digital. Oh, we need to look at this carefully to consider whether we have the right tools. And in particular, even if we have the right tools, I think the debate is also about, but okay, we can review transaction, we have the right tools, but there's a big information asymmetry. You know, we as antitrust authority know so much less than the party. So of course we need, you know, to review internal documents, which always play an increasingly important role. But I think there is a voice concerned about, you know, we need to know more, and you know, sometimes the documents don't even really get the full story. So how do we get the full story? But I think the third point I want to make is that even when you get there, and you have quite a big set of facts and documents, and you know, you've done interviews, you've asked from third parties, I think the difficulty about digital merger is that, you know, it has been recognized that this is one of the sector where you tend to need a dynamic counterfactual. So the normal crystal ball glazing that you have in merger control review, it's kind of on steroids, because you need, you know, your counterfactual doesn't necessarily need to be the, you know, situation, the current situation absent a transaction, but you need to look in perspective how the markets will develop, and those are fast-moving markets, clearly. And on top of that, we've seen, and you know, maybe I'll mention them later, a few cases where even alternative acquisition scenario have been considered, and that's something that we in the past we have tended to see in you know, when somebody was claiming the failing firm defense and you were looking at a less restrictive acquirer. And now it seems, you know, for instance, in some CMA cases, you look out, oh, you know, okay, let's consider you know, this market, let's consider what would have happened if another firm had acquired this target. So it just becomes horrendously complicated, but you know, even much more interesting. And that's why it's really important to be able to engage you know, proactively and early on with the authorities, because in some cases we just accept that an awful lot of work to be done and complicated, and one should work in a cooperative manner. Maybe I'll just say one last thing on that, just about, you know, do we have the powers? Mention, you know, maybe you know, probably at some point we should mention the Google Fitbit case. And I think, you know, without, you know, going into any detail, what was you know, what kind of struck me was the you know, the very interesting debate that you know, was developed along this case, because I think this was one of the first big high-profile case being tested in a scenario where there was such a widespread concern about something having fallen between the cracks in the past. So I think the community looked at this as a blueprint to see what's the Commission's approach now that they kind of voiced that you know, something might have been missed in the past, at least by some commentators. And I think the reaction to the remedies that the European Commission accepted in Google Fitbit is quite interesting, because on one side, I think, you know, a lot of people are kind of pleased about seeing how the Commission was, after all, ready to engage in a very, you know, pragmatic and, you know, somewhat complex set of remedies. But, you know, you have, for instance, the ACCC in Australia, we declare, okay, we are aware that the Commission kind of accepted the remedies, but we don't think those remedies works. And just to close off this, you know, this quick recap of what the reaction to Google Fitbit were, I think one thing that kind of struck me when I was following the debate was the speech that Shoshana Zuboff, as you know, the author of Surveillance Capitalism, and she commented on this case in front of a panel of the European Parliament. And I'm reading here what she said, because, you know, I think it's important to be aware about what is being said in terms of, you know, the level of scrutiny that some digital mergers should have. She said, any notion of approving the transaction is a serious mistake. And she also said, if the decision to approve Google's acquisition of Fitbit was made because of a determination that EU laws are not strong enough to defend the acquisition denial in the European courts, then let us please stop talking this minute. Let's suspend our event while the Parliament moves on into an emergency session to pass new laws that are strong enough to take this kind of rejection through the courts, because we need those laws. I think, you know, that declaration kind of sets the scene about the different voices that we are hearing in the field of digital mergers. And I should probably stop here.
Well, that was a good moment to stop, I think. No, it's very interesting. Thank you, Melinda. And it is really true that the debate and the fact that it's a hot topic, it is not coming from nowhere. So there's lots of different positions and different interests, I have to say, that come into play, and therefore it's good that you know, the more we discuss, the more, you know, these emerge, and we can have a clear view of what is at stake. Maybe now, Tim, I think we should, you know, Melina touched upon that, because I think it's a central theme for any digital merger analysis, which is, you know, what is the counterfactual? How you go about that? How do you really think you can predict the future, and looking at the transactions when you know the target company is a 5 engineers plus an idea, and try to develop a theories of harm in looking so distant in the future, because to become successful you can even in the digital sector you don't really need just a couple of months or a few years. And it is true that we've seen that we see the acquisition of disruptors, on the acquisition of, you know, massive competitors, also in other areas, in other sectors. And I think in the last few years in the US, we have seen transactions. I think I can at least remember 3 transactions in which the FTC moved to block deals where the target company has less than 3% market share. So we are more or less in the same space conceptually, but I think this is even more problematic for digital mergers. So what is your experience, and without asking you to comment on any of the mergers in which you are involved personally, but as an expert in this industry?
Yeah, and thank you, and thank you for having me at this festival and on this panel. It's an honor to be with you. I think Gianluca and Melinda, you've touched on, and I think you flagged. I think a lot of authorities are looking at the past and thinking, well, what did we get wrong? What mergers should we have looked at, and where did we go wrong with the counterfactual? Where did we not sufficiently predict the future? Where should we have blocked a transaction? And they're doing so sort of 5, 6, maybe even 8, 9 years after the event, with the benefit of hindsight, where everything looked certain, but at the time, obviously, everything was very different. And I think when you run retrospectives and you look back in time, everything always looks incredibly certain and foretold, whereas the reality at the time, when the authorities were reviewing these deals, it was anything but. And I think the counterfactual is central to a lot of that. And I think obviously Lear has done a fabulous report for the CMA a few years back on some of this, and explored this in some detail, and explored very particular transactions. And I think it would actually be interesting also to see, well, the authorities clearly think they missed a trick somewhere, but where also did they make a statement or prohibit a transaction where actually over time, the situation has panned out very differently to the way they predicted. I think there are a number of examples of that, one of which is Project Kangaroo, which has also been discussed at length, but I don't really propose to go into any detail here. Now, I think what Melinda pointed to was the increasingly fluid concept of the counterfactual. And I think when you've got the necessarily forward-looking framework of a merge control analysis, that shouldn't necessarily be misinterpreted. So the review only looks at potential competition or innovation-based theories of harm, while ignoring the actual relevant counterfactual in any proposed transaction. And it's the counterfactual I want to focus on, because part of the debate does seem to believe that the acquired business would always have achieved the same success on a standalone basis. And the reality in this environment is that many firms actually fail. And that's always been the case and will always be the case, because I think there's an undervalue placed on the skill of execution. And in this context, it's therefore difficult for authorities to assume that sort of ex post hits would have been successful under other circumstances. And I think whilst potential competition theories of harm are, of course, valid and applicable in certain cases, absent strong facts and evidence that the target company will succeed and compete on its own if the acquisition is blocked, those theories are difficult to sustain in reality, and you walk into areas of speculation. And I think that's especially true sort of in M&A in the tech sector. These environments are rapidly evolving, and the prospect of likelihood of future competition is therefore very difficult to predict. So it would be unfortunate to adopt lower thresholds for analysis for potential competition in the very sector in which the prediction of the future is so very difficult. And so when it comes to the counterfactual, my suggestion is that it has to capture the commercial realities of the industry that you're looking at. And so in other words, it can't be assumed that any given small startup would grow independently and organically to form new competitors. That's just simply not the commercial reality. That's just simply not the real world that we live in. And I think where you're sort of seeing an increasing tendency to adopt counterfactuals, and I think Emelinda may speak about this later, but that aren't based on what would happen absent the transaction, but rather what if the acquirer were different, then I believe we are in the realms of speculation, and we are making significant jumps. And it may come back also to sort of misunderstanding as to why companies actually use M&A and acquisitions as part of their sort of corporate strategy. And maybe we can come back to that sort of a bit later. But I think the reductionist focus on potential competition risks taking the pendulum a bit too far in the debates and the reviews that we're having at the moment.
Yeah, and absolutely. And I think I've heard in one of the various presentations, I probably was by John Fingleton or someone from his team, defining or using this term of potential competition as opposed to actual potential competition is a sort of a way to try to further distinguish potential competition in two different buckets. And the typical pharma potential competition analysis would be an actual competition analysis, because you would be sort of within the context of a sort of regulated framework where you have milestones, where you have steps, and where you can really assess how close to being a real market presence that particular product is, as opposed to potential competition, which is a squared potential competition, in the sense that is the difficulty to predict the future is magnified. And I think to make a joke, I think I've already made this joke another time, but I like it, so I didn't make it. It's, if you were so able to if an antitrust authority or an antitrust official were so able to assess the future in such a long distance perspective, and identifying successful companies, probably they should be changing job and be fund managers, very super rich fund managers, identifying what is really going to work or not, because it's very difficult for everyone to go that route. Moving to the third topic, and clearly, naturally, all these topics are strictly intertwined, and so I think the counterfactual point comes back many times. Melinda, if you can guide us through how can you then, in such a difficult sort of forward-looking potential competition scenario, how you go about trying to develop theories of harm which are credible and are not just creation, but are rooted in reality, as Tim was hinting to.
Yeah, thank you, Gianluca. I think like in the first answer, maybe also in this case, maybe I start from a practical example just to frame the analysis, and I would like to use as a test case the PayPal iZettle transaction that was reviewed by the CMA, because I think that's a kind of an interesting case study of the thought process where an authority has gone through. And I think, to remind ourselves why this case is so interesting, I think it was the acquisition by PayPal, we all know what they do, of this Scandinavian startup, which was providing offline payment systems that you can use with a mobile. And, PayPal was already there in that segment, but mainly it was doing it is doing online payments. And what triggered a lot of debate and attention on that transaction was that iZettle was on the verge of an IPO, and the expected valuation was 1.1 billion euros, and PayPal offered to buy it for double the price. And also on blogs and community, also between non-specialists, they say, oh, that's the smoking gun, they are paying that premium because they want to kill a nascent competitor. And I think that in that case, the CMA wasn't really didn't hesitate in assessing the rationale and the valuation of the transaction. And I think in a way that gives us a signal that when you are pursuing that kind of deals, you should be prepared to really think through what's driving your acquisition, because you will be asked to articulate it by the authority, either formally or de facto, because essentially in that types of transaction, we might discuss whether it's a good thing or a bad thing. Essentially, there's an element of intent in looking at looking at your intent in the transaction that some commentators have kind of developed in a way to say, well, should there be transactions for super big players that should be looked at as restrictive or competition by object? So I'm really not proposing to go into this, but I think the takeaway, and to respond to your query, Gianluca, what do you need to think early on when considering a possible theory of harm? I think that a fact that we are saying is that valuation, internal document, objective of the transaction, the deal rationale is not going to be the usual 3 to 5 lines that you put somewhere in a form CO, but it's it's something which is becoming more important. Then clearly, I guess, and we're coming back to a common theme here, theories of harm based on a dynamic counterfactual. For instance, in that case, the CMA went into quite a bit of detail in saying, well, PayPal is already active in the offline in the offline segment to some extent, but there is no way iZettle would have reached scale in an omni-channel, so online and offline world. And the authority was much more open to, looking at the, the positive, looking at the efficiency is really always a strong word about, merger control assessment. But indeed, there was quite a bit of scrutiny on, where the market would go into even this faster moving space of fintech. And essentially, a third point that you really need to consider carefully in those type of merger is, the actual or potential competition active as a balancing force in the greater scheme of things. And I think here probably a paradox that we are experiencing in a number of cases is that your target firm is construed as this fantastic competitor that in 3 to 5 years' time would challenge your position, but then all the other firms that you are pointing to as actual or potential competitor with very interesting growth potential are kind of discarded as, oh, not quite there yet. And I think that's gonna, quite a lot of the work that we probably would need to be doing in the next few years is really, find a way to, at least consider applying the same thought process and the same rigorous approach in assessing where the target form would likely go, but also where all the other competitive forces out there would likely go. So I think these are the three big buckets where I would invest my energies in terms of, identifying theories of harm early on.
No, say, I don't know whether Tim, you wanna comment on this, or should we move to the next topic?
No, happy to give a quick comment, and maybe specifically with respect to, I think, one of the hot topics at the moment, which is data, and how that features in sort of a merge control assessment. I think the European Commission has set out its framework. I think now it goes back a few years, probably to Microsoft LinkedIn, where it set out sort of how it would consider data theories of harm within its sort of competitive assessment, doing so both on obviously the horizontal and vertical. And I think there are two central themes that come back and sort of filter through in both of those appreciations, which is one, sort of what market would the potential data be used as an input into, and where would it feature as an input? And so Microsoft LinkedIn, I think it looked at online advertising, I think it looked at CRM, it looked at productivity software. I think you're seeing a similar sort of assessment run in Google Fitbit as well, and that's quite an extensive assessment. It's quite a thorough assessment, and sort of they're looking at that and thinking through sort of where the data is used, and then sort of developing sort of the horizontal and the vertical assessments. And then at that point, you've got the second limb, which also filters through both into the horizontal and the vertical, which is sort of whether there are alternative data sets to the ones being considered in the merger, and whether it's sufficient actually to have similar data sets or data sets which are comparable to the ones sort of under consideration. And I think in Microsoft LinkedIn, that was sort of central to the analysis. And I think that there was a finding that the alternative CRM, competing CRM providers would have alternative data sets in order to inform their machine learning models. And that was sort of run through in the competitive assessment. I think a similar assessment appears to have been run in Google Fitbit, perhaps with a slightly different conclusion by reference to certain types of health data and their impact on online advertising. And so maybe that's why you see the remedy that you do in Google Fitbit. I think the question there is perhaps, has there been a willingness to discard potential efficiencies from some of that data aggregation? And are we perhaps seeing sort of an efficiency offense creep in again into merge control? And I think that's a very real question. And perhaps when we're considering theories of harm, that's also kind of the other thing to consider, which is sort of how are you going to show efficiencies? But we may get to that a bit later as well.
Thank you, Tim. And that last point, I think, reminds me that I think from a regulatory perspective, from a legal perspective, if to go in a sort of efficiency offense type of route in merger control would be contrary to the actual legal rationale of merger control, which is there is a merger privilege, which is attached to mergers as opposed to cartels. So I think that would require a legislative change and would be sort of fair game, so to say, if for appeals in case you really were to go that route. I don't think that the Commission will ever expressly do that, but as a matter of fact, that's a reality, and we have heard officials stating this in very open fora, and so I think this is something to consider. But let's move to another area, which I think it's very interesting, and I think originates from an article of at least as far as I'm concerned, by Andrea Minuto Rizzo, an Italian antitrust official, and which essentially reversed what was the common thinking, at least in general terms, that we had, I personally had on the matter. Which is, well, if the likelihood of being acquired by a large digital company in relation to a startup is an exit for the investors, and therefore there's a strong incentive for investors to invest in startup because of this exit that is there. At the same time, this article essentially suggests that the contrary could be true, which essentially would seem to indicate that there is less support, less investment, less financing, seed financing, angel financing, venture capital financing for startups which operates in the space which is covered by the large digital champions. And so it's very difficult to find, for a lawyer in particular, but also for, I think, for everyone to have a clear view. And so it's important to understand what really the industry is doing, what is the situation, what's the feeling. And so this difficult question goes to Tim in particular, if he has any view from his perspective of what is happening in relation to whether killer acquisitions are really killing investments in startups, or it's true exactly the opposite. It's a good way to exit and therefore an incentive to invest.
Thanks for that question, Gianluca. Look, first, I wonder if actually the term killer acquisition, at least in the tech spaces, that I wonder if I'm perceiving a shift in that debate. I think there's an acceptance that killer acquisitions aren't really sort of a feature of the tech sector. And I think we're moving on from that. I think that was a debate prompted by an article a few years ago about the pharma sector, but maybe we're moving on. And I think it's interesting, actually, when you look at some of the surveys out there. I think I've mentioned it before, but there's a survey from the Silicon Valley Bank that asked startups, around 1,400 startups, about their long-term goals. And 50% indicated that their primary aim was to be acquired. 15%, I think it said they didn't know exactly, but I think the promise of being acquired, as you said, is spurring innovation and the birth of startups that otherwise perhaps wouldn't have been born. And I think that the number of tech startups that you're seeing, sort of based on some statistics available from the NVCA, suggest that we're seeing sort of 3 to 4 times more startups than we were a decade ago. And so those same stats would suggest actually that early stage investment, at least in the US, has risen constantly and consistently since 2005. That includes early and angel seed investors. And in recent years, sort of venture capital has had sort of a number of bumpy years. And even in 2020, I think, at least in California, where you see an enormous startup industry, I think that was a record year for VC investment. So I'm not sure I recognize the idea that VC funding is not available or decreasing. I don't think that's sort of consistent with the stats that I'm seeing. I think you've had VC interviews done by various surveys, and some of them actually point to the finding that the connectivity and the infrastructure enabled by companies such as Facebook, Google, Amazon, and the like sort of serve as a propagator for continued growth in the market. In short, these companies act as a growth factor for VC funding. I think if you look at recent examples of VC funding sort of in areas close to us, I think you see Clubhouse sort of reportedly raised sort of a Series C funding round in April a few months ago, and they reportedly valued the company at $4 billion. And I think that tripled the valuation that was associated with it back in January. So I think that VC funding is there. I think when you look at the growth of TikTok and Musical.ly back in the day, there was no shortage of funding for those options. I wonder though if we're looking at and confusing sort of maybe sort of mature technologies and thinking about mature technologies and maybe seeing drops there. And you know, I'm not sure that if you go to a VC fund and say, I've got this great idea, I'm going to build this new email, company, I'm not sure you'll get a lot of funding. Likewise, if you go in with your typewriter, it may not work. So I wonder if there's a bit of sort of confusion there. But no, I don't think that's consistent with the trends. And look, I mean, you're seeing increasing VC funding available, not just in the US, but also sort of in Singapore, in China, in APAC. And so I think it's on the way up. I don't think the trends are pointing anywhere else. But if there are to be drops in VC funding in future years, then maybe we need to look at some of the changes that we're introducing to merger control at the moment, maybe.
Fair point. Thank you, because you're giving us a little bit of a window into something which is externally difficult to judge, and you just take the commentaries and as they stand. Melinda, do you have any comment on this, or?
No, I think like somebody said, after the financial crisis, the Nobel for the economics should go to the benefit of hindsight. Like it's really difficult to say in advance. But I think we're short on time, so I won't further comment on that.
So yes, we have the last 10 minutes or 5 minutes, so we leave some space to final comments if there are. That we can respond to, and I think it's then it's a big question is what we do then. Having heard the various positions and various comments, and being aware of the debate, which it's on one end pretty consistently going forward. The tightening of the rules and or tightening of the enforcement discretion and application of innovative theories of harm, and what are the solutions, because it's merger control has always been considered a tool that was something that aimed at giving legal certainty to the deal makers. So you had the the notification mechanism in a relatively short time within which there was a decision, good or bad. At the same time, we see the ex post reviews, which has always been a feature of the US, but applied more, being considered as a tool for going and reviewing transactions which happened many years ago, particularly in the digital sector. We've seen ex post reviews being introduced also in other countries. We've seen expansion of the thresholds in order to capture mergers that they've always on the basis of the criteria that we're using the old economy were less than relevant. And at the same time, we hear the use of different tools, the regulation as a primary areas that is developing, which is not strictly concerning mergers or transactions, but nevertheless it would have an impact on that on many fronts, in particular on the relevance of the data, and as Steve mentioned. And then we have the Article 102, the monopolization, which I think could be seen as a solution using the toolkit that exists today. I'm sure the team would have a comment on that. But in general terms, one could see 102 as more adapted to assess these type of transactions, because you would not be speculating, but you would be looking ex post with some evidence, concrete evidence of what the evolution may be. So you or how that could be assessed from an antitrust perspective. And naturally, then the typical critique is, well, but unilateral cases are typically very long, and there's no legal certainty in relation to a transaction. But then that's probably the issue. Then the issue would be to try to reduce to a much shorter duration Article 102 cases, which would also have the possibility of eliminating the speculative nature of some of the assessments that are done today. So between the use of merger regulation and the expansion of both the merger thresholds or the reportability conditions, as well as the theory of harm, the regulation and the use of Article 1 or 2, what is your final view on these three potential solutions to the problem? This is the big question. So
yeah, it is a big question. And Gianluca, I would say that probably what we want to achieve is some degree of certainty. So, frankly, I don't think we were overly shocked by, changing thresholds. If you think that the thresholds need to be changed, fair enough. And I think the Austrian and German authority did a good job, also in providing guidance on how you should apply the threshold, being open for consultation, and in a way also based on the experience of our colleagues in Germany and Austria, that at least in our experience has worked quite well. I think we were all looking at the Article 22 move of potentially calling in mergers which do not trigger notifications anywhere. Well, that raised quite a few eyebrows, and I think one way of dealing with it is possibly building on the experience of our colleagues dealing with the CMA and submit a briefing paper, and rather than just do nothing and see whether anybody's interested in the transaction, proactively be able to identify those transactions where an ex-ante dialogue makes sense, because I don't think that for companies there's any real appetite for an ex-post review. So, all of this to say that I guess the position is we want, as much as certainty as possible, provided that it's not that a certainty that any digital merger will be blocked. I guess that we all agree on that point. And so essentially, I think, if there's a perceived under-enforcement, let's look at these transactions, let's consult on them, and let's have an upfront discussion and review the case ex ante. But if we are talking about merger review, at its core, it is a prognostic assessment, and kind of changing it and squeezing it into something ex post, that doesn't sound very right. And of course, there are some perceived problems that maybe, and there's a whole debate, and we could do a whole festival about that. But if you want to have a regulatory or para-regulatory solution, fine, that's also good in terms of certainty. But probably we do not want to change the heart and the core of merger enforcement, which is an ex-ante enforcement. And I'm sure Tim will also have some thoughts on that.
Yeah, sorry if I step in, Gianluca, we're running a little bit late. So if you can, summarize.
I thought we had until 5, so it was
until 4:45.
Okay, so just a final comment for Tim.
For Tim, yes.
Yes, last word to Tim.
Okay. Give me let's say 20 seconds. So look, I think it's very good to have this healthy debate, see what we've done wrong, what we could do better, what has worked, what hasn't worked. I think it's been I think it is a thoughtful debate. It might need in certain circumstances to be more nuanced. I think certain parts of the debate have taken it perhaps a little bit too far. We may see the pendulum swinging too far. I think the Lear report was an excellent report, and I think it flagged a lot of the efficiencies from these mergers. And I think if there's anything that should come out of this, it's actually looking at these mergers, thinking about sort of what the efficiencies were, what made those mergers so successful, and how can we reflect that in an efficiencies framework? Because if we're going to ask and insist that parties come forward with efficiencies, let's have a framework for that, so that when they do come forward with efficiencies, they're not told, actually, that may creep into sort of offence territory. And I think that would be a very welcome development. I think we need to be careful not to take the pendulum too far. I think it would have a chilling effect on pro-competitive M&A, pro-competitive deals. I think it would have a knock-on effect on startup investment in VCs, as I've mentioned. And that may be my final word, and I'll be quiet now.
Thank you, Tim. Thank you, Melinda. Thank you, Paolo, for your patience. Sorry for the delay. I thought it was 5, but it happens. Sorry. Thank you again. And,
okay, thank you very much to Gianluca, Melinda, and Tim. Tim, there is a question in the chat for you, so if you want to follow up in writing, that would be great. All right, so okay, very good. Gianluca, if you can stop sharing your screen, we can move on. And I'm very excited for the next session. The next session is about the Young Talent Competition Award, and I'm very pleased to see that the members of the scientific committee are already connected, and also the young talents that have been shortlisted for this session. So let me say a few words about this initiative. We do think that research is very important in our field, and I'm pretty sure you share this feeling. And I'm also convinced that many ideas can come from young researchers that have a lot of energy, a lot of ideas and creativity to put into the field. So we launched this award a few months ago, and we were very pleased to receive many interesting research projects from around the world. There was an initial selection that was done by Lear internally on a number of criteria, and then a smaller number of research proposals were handed over to the scientific committee, and they independently of each other made a ranking of the proposals, and then we selected the best 3 proposals. Now, this session is organized in this way. It's not really organized, actually. So anyone who wants to step in and say what they think among the members of the scientific committee. Tommaso, if you want to switch on your webcam, that would be great. Okay, I can see you now. And we have actually decided that 3 of the members of the scientific committee will make a short presentation of the research project. Then the talents that propose these research ideas will have 10 minutes to make their presentation. If you can keep it in time, that would be great. And then Joe is going to announce the winner of the competition. So let me thank Michele, Bill, Joe, and Tommaso for their wonderful contribution. And I think we can start with Tommaso.
Thank you, Paolo. Thank you to Lear for having this great initiative. I may sound a little bit parochial, but I think it's great that you're financing research. This is badly needed. It's an interesting period, I think, for research in competition policy. It had become a little bit stale for a long period, doing the same kind of stuff, especially in my field, industrial organization. In the past few years, I think a number of people try to expand the boundaries and make competition policy, interesting again, and all the conversation we're having, the debates is a reflection of that. So there is great research coming out, and more needs to be done. So it's a fantastic initiative, and you're very generous, Paolo, and your company for trying to support efforts by independent researchers, and I stress independent because this is something which is badly needed in this field. So it was a pleasure to contribute to this. We read some selected proposals. There were, the spectrum of ideas was pretty large. Obviously, funds are limited, so we could just select one. But I know there has been lots of head-to-head competition. I should say also that the general themes despite the variety, were a couple. There was a certain number of themes which were along self-preferencing and trying to understand these algorithms. What do they actually do? Because we need to, and it's very difficult to understand that because it is a black box. But one set of papers and proposals were related to algorithm and self-preferencing, and this idea of being both a referee and a player in the same industry. This is something that people are really keen to open that box and having good independent research. And the other theme that was coming from the proposal was about acquisitions in the tech industry, because sure, we heard just now Facebook's view, but we're still counting about 1,000 acquisitions and we are still at a 0 for prohibitions. And if you want to do a proper study, you need to understand the counterfactuals. And it's not just about asking random people what they think, but you need to do that in a thorough and robust way. So these are the type of ideas that people really, and they had ideas of how to do that, how to get along. So I will introduce the first paper that was selected. That's a paper, well, a proposal. So we will want to read the results very soon. It's called Taming Tech Giants Algorithms, the Amazon Buy Box Case, by two postdoctoral students, Francesco Clavera Braulin, who's currently at ZEW in Mannheim, jointly with Michela Bolledrini, who's a postdoc at University of Turin, which is my hometown, so great. So they are going to present what they're doing, but as I said earlier, they want to understand the ranking algorithm in the context of Amazon. There is some of the papers that have already started looking at that, but they want to basically understand persistence in the buy box, what explains and what does not explain persistence, and ultimately they're interested to know choices and whether these choices are good for consumers, because it's a metric that we analyze. So Paolo, if that's okay with you, perhaps we should ask who's on the call, both Francesco and Michela, or I don't know how they are going to allocate their time.
Michela is here.
Okay, so
I think she's going to present.
Very good. So I was very happy to read the proposal, this one in particular, as well as the others. But I think this is really something that the policymakers are discussing. We would like to know the results already right now in order to influence the debate. It will take a bit of time, but hopefully not too long. So congratulations for being short listed, to Michela and to Francesco.
Okay, so I think I can start.
Yeah, sure.
Okay, so thank you everybody, first of all, for having us here. And I think both Francesco and I are truly happy to have the chance to present you this, what I think is more, as Tommaso said already, is more a research agenda than a full project yet. And so I have some slides, so I will try to share them with you. And I will try to be super brief in presenting all the different points we are trying to tackle in our research project. So I hope you can see the slides now. And okay, so the title of the project is Taming Tech Giants Algorithm and the Amazon Buy Box Case. So what we focus on is exactly the Amazon Buy Box Case. And I will start by telling you what we label as the buy box. As you will see, this is something probably all of us run into like at least once in our life when searching or buying something on Amazon. So what is the buy box? Is basically, imagine you're looking for a product on Amazon, and this is a very nice example of a 90s object that is the one-time camera that we used to, I used to play with when I was a kid. So imagine you're looking for this product. Once you select the product, what is shown to you on Amazon is the characteristics of the product and the options you have here in terms of the characteristics of the product itself. On the right side of the page, what you see on the upper right side is this rectangle with all the information on what would be the default deal you would get if you choose to directly purchase the product by clicking either on the Buy Now button or alternatively on the Add to Cart button, which basically keeps the deal into your personal cart, and then it eventually gets implemented once you choose to actually go through the payment and get the product. So what is shown, what is important of this buy box is that what you can see from the buy box are just the information on the deal you would get from the default seller that is somehow behind the deal in the buy box. So you will get the price that the default seller would propose to you, and all the characteristics in terms of shipping and quality of the seller that only refers to the default seller. However, just like one click away, you have this other option to see all the other sellers that are listing the same product. By clicking on the second button, you get to a secondary page that tells you what are the other options you could get to get the same product from all the other sellers listing the same product, which, as you can see, even from this like super simple example Francesco and I chose last week from one of the basic bestseller product on Amazon. For example, the other sellers are listing the product for the same exact price and the same shipping price. So let's say there's a high competition, especially on some products, and we are very interested in understanding what makes the default seller be the default seller. So what is Amazon looking for when selecting the buy box seller, which has a very prominent position on the platform, as you saw from the product page. So more or less, as Tommaso also anticipated already, what do we care about this problem? The main the main feature of Amazon that makes this problem interesting to us is that Amazon plays on like a dual role on the platform, because it on one side shapes all the rules of the game, so that it basically decides what is the design of the platform, so what both consumers and sellers know of the other side of the market, and at the same time also plays itself as a seller. And this may give Amazon somehow an unfair chance to exploit the power it has at the expenses of the other players in the game. We focus on 3 different points with respect to this broad research question. And the first point we address refers to a more competition policy perspective. That is, we want to try to understand what is behind the dynamics of the buy box algorithm. I should have mentioned maybe the algorithm is as a complete black box, so we don't know what makes sellers get a higher chance to be selected in the buy box. And yet we observe that some sellers, for example, persist over time in the buy box, and this may give them somehow unfair advantage over other sellers. And so the first point in our research agenda is to understand what is basically explaining the dynamics in the buy box selection, and whether this dynamic can affect competition in the market. At the same time, we also look at the consumer's perspective, and we want to look at whether consumers are actually, what is the level of information consumers have on the power they have on the platform. So what do they know about the buy box? Do they know they have other options on the platform, and how costly it is for them to get this other information on these other options? And also we want to understand whether consumers know that what they see may be personalized by the platform, and how they would respond to that. So this is more or less like what we do. I will just now go a little more into detail in for the 3 different points, and then I will stop so that we can try to be on time. So the first point exactly addresses what I was telling you before. So what is driving the persistence we observe in the buy box position? So we want to understand what are the features that explain buy box selection, and what are the consequences of this somehow extreme form of ranking algorithm. Because as we know, the seller that ends up in the buy box has an extraordinary prominence on the platform with respect to all the other sellers that are on a different page of the product. And how we want to go through this project is to basically, we want to collect data scraped from the Amazon website to gather information on all sellers listing the product, so that we can try to model what is explaining the dynamics in the selection of the buy box seller. So to understand whether dynamic partner whether the dynamic pattern of buy box selection could be somehow affecting the price dynamics on the market and sellers' behavior. And our main hypothesis is that if there's some form of unexplained persistence, this may affect sellers' behavior, because they get this advantage and they can play with it at the expenses of consumers, knowing that the buy box position gives them a high power with respect to other sellers. The other 2 questions focus on consumers, and we want to basically understand what do consumers actually know about the platform, and how is their behavior affected by the information they have on the platform. With respect to this, what we want to do is we want to run a sort of quasi-field experiment. This is like a definition I made up, but I think it's like very tightly connected to what we are planning to do. So what we want to do is basically collect information on consumers. So what is their history? What do they do on Amazon? What do they know about Amazon right now? And look at how they behave at the same time on the market, scraping information, tracking their behavior on Amazon, incentivizing their choices. So we were basically going to give them money to make their purchases, and we're going to study how their behavior is different over their history of purchase, their characteristics, and also conditional on the information we're going to provide them on the platform. So we're going to tell them they have other options, and whether we're also going to tell them that the buy box algorithm may not always be the best choice for them. So on this note, what we were going to look at is basically whether the information affects behavior of consumers, and whether this mechanism may be explained by a change in search costs for consumers once they know they have other options, and a change in their trust in the platform once they know that the default option they see is not like transparent the way it is selected. And lastly, the last thing we want to do is to look at whether and to what extent search results are personalized on Amazon. And eventually we want to, this is also something we're going to do, collecting data online on what people actually see when they log in Amazon, based on whether they have a history or past purchases on the platform or not. And we're also going to look at whether this affects, for example, what is shown in the buy box. So that the buy box is also, for example, targeted to the characteristics of the consumer. So to maximize, for example, the chance of getting the purchase concluded in the shortest time possible, for example. And so this is the last thing we're going to address. And so we're going to look at this and try to quantify and eventually look at the heterogeneity in these forms of personalization of the platform. And this is basically it. So thank you again for giving us the chance to present the project. And we are a very preliminary stage, so not sure whether we're going to get results, like useful results, in a very short time. But we're very happy to get your feedback, also because we're still like designing some of the parts of the project. So thank you again for giving us the chance. And I think I leave the floor to you.
Okay, thank you very much, Michele. As you said, it is more a research agenda than a single project. There is a lot of stuff, but we all liked a lot your ideas. Now we have to move on. Michele, the floor is yours. Can you say a few words and introduce the next candidate?
Thank you, Paolo. Good afternoon, everybody. It's a really great pleasure for me to be here with all of you, even virtually. I would have preferred to be in person in your wonderful locations, Paolo, in Rome. Well, go directly in presenting the work of the candidate, which is Louise Eisfeld. She's an economist. She submitted a very interesting proposal for her research. It is a very concrete one, a very actual one, and it has been showed by the panel we have just assisted organized by our colleagues from Freshfields, because it was exactly that topic. So this shows how complex it is to assess the acquisition of startups in the digital environment, and how strong are the relations of this kind of acquisition in the society. So what I have been very much appreciated is the idea to see if the startup is relevant from the antitrust perspective, since the ex-ante analysis. And this is mostly what the competition authorities do when they assess the merger control in traditional markets. So the things are very much complicated in startups, and I will leave the floor to Louise to tell us something more about this very interesting research proposal. Please, Louise, the floor is for you.
Okay, thank you so much for this kind introduction. I'm really delighted to be here, at least virtually, with you. Let me also share some slides. I think you should be able to see them now. Okay, so let me present this research proposal whose title is The Acquisitions of Startups and the Entry of Startups in Software Markets. And as you said, it's directly related to the panel we just had before. So first, let's have a look at these data. So this plot shows the top 10 companies in terms of the number of acquisitions of startups which they have purchased in 2005 to 2020. And by startups, I mean companies that have received venture capital funding in the past and that are typically young and highly innovative. And perhaps unsurprisingly, Google and Microsoft are topping this list. The other so-called GAFAM companies are here as well. There's Apple, Facebook, and Amazon, but there are also a few other companies like Cisco, Oracle, IBM, Yahoo, and Salesforce. So what is really striking from this plot is that it seems that startup acquisitions are especially important in software markets, since all of these companies produce some sort of software, sometimes also hardware, but software for sure as well. And now the big question is, of course, how should we think of these acquisitions of highly innovative companies? And as has been said in the panel before, the emphasis, I think, is on dynamic concerns and not static concerns, since these startups often have very small market shares. And we have heard before that there's one thought is that the acquirer might actually remove the potential entrant and shut down the project, which is the so-called killer acquisition. Another thing that might be going on, so another implication of these startup acquisitions could be that startups correctly anticipate that they are going to be purchased by a large incumbent, and therefore they are innovating on something incremental that is really useful for the acquirer, but perhaps that is not as radical and that is not really opening a new market. This would be this sort of so-called innovation for buyout incentive. And also, this is related to the so-called kill zone. So the prospect of a buyout may actually reduce early adoption of the startup's products. So consumers might not want to pay the switching cost to try out a new product that is developed by a startup and might stick to the incumbent's product, anticipating that the startup will be purchased eventually. So this research really focuses on this dynamic perspective and focuses on startup entry and what is termed competition for the market. And the setting where I'm planning to explore this is the market for enterprise software. And I have two data sets available. So the first data set is commonly used in empirical finance. It's called Crunchbase. And essentially, it gives me a panel of both startup firms, so all firms that are prone to being venture capital funded, and also all sorts of larger firms worldwide. And essentially, what it gives me is that I obtain a panel of all the important company events in a company's lifetime. So I see entry, I see funding rounds, I see acquisitions, IPOs, and so on. And the second important data set stems from Capterra. Capterra is a vendor and comparison tool for business software. So its purpose is really to categorize software and to guide consumers in finding the right software that fits their purposes, that has the appropriate functionalities. So it takes probably really great care in categorizing these software products correctly. And also, I can obtain reviews and ratings, which could be viewed as some measure of demand from this website. And so my contribution, my first contribution of this paper would be to match the firms in Crunchbase to the products in the Capterra data, and then the product functionalities and descriptions of Capterra can be used. So I can use machine learning techniques to then accurately cluster all these enterprise software companies into distinct markets so that I end up with quite accurately defined markets based on the software functionality. And now, how can we get at the big question of what is the effect of acquisitions? Well, first we can try to look at so-called reduced form evidence. And now the challenge is really that that we cannot just make before-after comparisons with acquisitions, because acquisitions are inherently endogenous. Acquirers take great care before acquiring a new startup. Of course, they take into account how innovation is going to develop in the long run. So we would need something exogenous that would shift the likelihood of acquisitions without affecting other aspects of doing business. And there is some anecdotal evidence indeed that certain policies might have affected the costs and benefits of certain types of acquisitions. So I have a couple of candidate policies that I'm currently exploring. However, it's not entirely sure yet if this approach is really feasible. So we need to really look more deeply and think more deeply about whether we think of these policies as being exogenous, and also if we see any effects that are strong enough to yield identification. And therefore, I'm also proposing a more model-based empirical approach. So here I plan to build a dynamic game of startup entry and competition. So essentially the plan is to set up a model of economic agents who are forward-looking and strategic. So the economic agents are startups and potential acquirers. In this model, startups can transition through stages of maturity. So this can be the funding rounds that I see in the data. And both startups and potential acquirers or incumbents can take strategic actions. So startups can decide whether to enter or to shut down at any point in time. And the incumbents can make an offer to acquire a startup. And again, startups take into account the likelihood at which they might be acquired in the future. And the key parameters that I wish to estimate here would be the cost of acquisitions and the entry costs. So cost of acquisitions could be pinned down by the policy changes that I mentioned before, and the entry cost can be pinned down by observed patterns of entry. So that in the end, this model could explain these patterns of entry that we see in the data. And why this model? So the nice thing is that in the end, I hope to have estimated the preference or cost parameters of these firms. And then we can perform counterfactual experiments. So we can change one parameter. For example, we could think of what happens if there's a reversal in the burden of proof and acquirers need to first, it would make acquisitions much more costly for acquirers. And then we could trace out how would startup entry and competition evolve under this scenario. So I think I'm out of time. So let me just say that there's very little empirical literature actually dealing with innovation in software markets. But I think we probably, most of us might think that it's a very important market and it has to be studied. Measurement is difficult, but I hope to circumvent it using this product level data that I have. So thanks a lot, and we're very happy to receive your comments, of course, since this is also ongoing.
Okay, Luis, thank you very much. Your research is very much needed to answer all the very important policy questions that have been raised during the previous panel and in many other panels. Now I want to move to Bill, but let me just say that we didn't receive proposal only from economists. I mean, there were also lawyers, and the committee is actually made by 2 lawyers and 2 economists. So it's by chance that we have only the candidates from economics. Bill, the floor is yours.
Thank you, Paolo. I'm thrilled to be part of this wonderful panel and part of this initiative for 2 reasons. The first is I'm greatly heartened by Lear's commitment to the common pool of knowledge that supports our system and your active faith in enabling promising researchers to achieve the fullest expression of their potential. Competition law is linked to the science of economics in a way that no other field of law is connected to another academic discipline. And it means that the success of the entire endeavor depends vitally on the quality of the intellectual infrastructure that it sits upon. And if we modeled our field as a firm, this is an area in which the firm fails unless it's investing in research and development on an ongoing and significant basis. And this long-term investment, as we know, does not immediately produce results. You're generating benefits that will serve the community over the long term. And in many ways, we might not be around to observe the full impact of this work, yet you've made it anyway. So I'm very heartened anytime I see that gesture, those who plant trees rather than those who simply collect fruit. The second is that this process permits me to see the promise of a better future in the face of our researchers. The greatest pleasure perhaps of being in teaching is that you get to see firsthand the commitment, drive, knowledge that will enable a new generation to solve the spectacular problems that the old generation is leaving behind and running away from, either through retirement or permanent exit. But it is heartening to see the face of a future where the capability and the commitment to take those on is present. And this exercise has reminded me again why, in many ways, I wish I was 30 years younger, because we do have that kind of extraordinary ability, creativity, and drive to carry it out. And one of those is Tai Lam. Tai is a PhD candidate at Northwestern. Tai's topic is platform search design and market power. And as Tai will describe to you, he's looking at how market power arises from a platform owner's ability to choose the arrangement of products that consumers use. And for several reasons, it's such a promising project. First is that he's going to shed light on it on the consumer search process. Interesting connections to consumer behavior and insights about how consumers search, to use the intuition based on our experience in the old days of shopping, how we're influenced by the placement and location of products and the ease with which we can reach them when we would go through the traditional store. Second, he has a superb empirical focus. He's looking at Amazon's product arrangements. He has a very promising approach to collecting and reviewing data that involves Amazon's product arrangements. And third, there are good connections here between theory and practice. He is quite attentive in his proposal to the impact of his work for the formulation of remedies. So he is interested in his work in connecting the high aspirations of research, theory, and modeling to what competition agencies ultimately must do, a powerful and interesting focus of the previous panel. And I invite Tai Lam to offer his own further thoughts on his project. But again, it's so encouraging to see in the work of all of our young researchers what promise, ability, and knowledge they will bring to the future of the field. Tai Lam, please.
Thanks, Bill, for that great introduction. And thank you for the committee for letting me talk about my project. Let me share my screen. Yeah, so my proposal is about platform search design and market power. And for this particular audience, it's not surprising that policymakers are interested in the market power that online retail platforms like Amazon exert by being a gatekeeper. So let me tell you how I think about this process. So marketplaces like Amazon have large number of products and almost as many small and medium-sized businesses that potentially compete with the platform owner. The consumers that shop on these platforms aren't actually going to take into account as many products as there are available. Rather, what happens is that Amazon decides what products consumers see when they search, and therefore what customers these SMBs can actually access. This gives rise to some natural questions. How are consumers and small businesses affected in terms of welfare and profits? And of course, also, what would be the effect of proposed antitrust actions like vertical divestiture? Although I might not be able to get to this part in this presentation. So what I do in this paper is I use search results data to estimate a model of consumer search and firm pricing to answer these questions for the US Amazon platform. Let me provide a little bit of characterization of the platform that we use for. There's going to be consumers that value variety, dislike price, and dislike searching. Amazon is the operator of the platform, but it also sells on the platform. And it's going to sell core products, by which I mean common brands and also potentially an Amazon brand. And they're going to be quite price competitive. Small and medium-sized businesses are also going to be selling common brands, but also fringe products and tend to be less price competitive. It's important to note that SMBs account for roughly half of sales, and so they contribute quite a significant amount to the value of the platform. So let me get into the details of how search design affects market power. Search results are actually the main way that consumers discover products. So here we're thinking about a consumer who has unit demand for a waffle maker. And the information on the right is probably familiar to a lot of people. It's what this consumer is going to see. Now, my claim here is that the position of the product affects the seller's competitive environment. There are going to be some consumers who have a high cost of time and a high search cost, who may only take into account a few of the products in the search results before deciding it to be optimal to stop searching and make a purchasing decision. Not all consumers are the same, and so there's going to be consumers who are willing to search further and take into account a greater number of these products that you see here. And so what this boils down to for the sellers of the products here is that a higher position means more consumers and less competitors, particularly for those high search cost consumers. So if you imagine a seller further down in the search results, they only get access to consumers who search all the way to them, and they're competing with everyone above them for those consumers. So the platform owner chooses this particular arrangement, the ordering of the search results, and influences competition that the sellers face, their ability to price. We can think of the information on the right as being codified in terms of the position, where the position of 1 is the best position. And I'm going to collect this information repeatedly over multiple search queries over multiple weeks. And we can think about a particular product, following it, and thinking about what its average position in the search results are. And I want to show you that statistic broken down by products that are sold by Amazon and products that are sold by small businesses. And so this is what that looks like. And the main takeaway here is products sold by Amazon are better positioned than SMB products. But I have to caution, this is not necessarily self-preferencing. There are many reasons why we might observe this particular distribution of products. For example, the search results algorithm may have learned over time to show desirable products, and Amazon is coincidentally or endogenously more likely to sell those desirable products. And so the whole topic of self-preferencing is a difficult one to get at. To kind of address or to kind of think about this, I'm going to answer a simpler question, which is, what if we eliminated this positional difference between Amazon and small businesses? To do this, we need a structural model of consumer search and firm pricing. And I'm going to estimate it using search results and buy box data, although I won't focus on the buy box aspect today. So let me tell you a little bit more about the data. I'm going to collect information on 50 categories in the kitchen and home goods overarching grouping, so waffle makers, etc. Most of my analysis is going to be done at the product week level, and I'm going to focus on the top 20 products, which is going to capture most of the market share of that category. And I'm going to follow that over 15 weeks. Since we're interested in, I'm making a claim about the position affecting the seller's ability to reach customers and therefore demand, there's a natural regression that we can run. So I'm going to do that. On the left-hand side, I'm going to have sales rank, which is a proxy for the ranking of market share, so demand. And on the right-hand side, I'm going to have price, position, and interaction of the two, and product fix effects. And I apologize for speeding through this, but the idea of this regression is we're following a product across weeks and thinking about, as the position of the product changes in the search results, is there a correlated change in the demand for that product? And over the rough takeaway is, yes, we do see that correlated relationship, there's sufficient variation to actually estimate it. And it is in the expected direction. Now, we don't want to interpret this causally necessarily. There's potential endogeneity from demand shocks. In the structural model, I'm going to correct this with IVs. And we have nothing here capturing search costs. It's kind of an omitted variable. If we were to change positions of the products, consumers would change how far they actually search. And so we can't use a reduced form approach to consider alternate arrangements of products. So let me give you a very simplified version of what I do in the structural model. On the supply side, things are pretty standard. Prices are going to be set as in differentiated goods, Nash-Bertrand. The demand side is where we're going to change things up by including a search process. Consumers are going to start with no products, and they can choose to search, which is going to let them draw products from the empirical distribution of search results, that information that we collected. And it's going to respect the positional order of those search results. They're going to make this decision optimally, having rational expectations of the products. And at some point, if they find it optimal to stop searching, they can do so and make a purchase from the products that they've actually drawn. So here we're trying to model that search results process. A few other things I want to point out about the structural model, it's consumers are going to be heterogeneous in search costs and price sensitivity. I'm going to assume it's a bivariate normal and allow for correlation between those two factors. It's going to look like a random coefficients logit, except we have search. And I solved the search problem in a way that augments standard demand estimation techniques. But what do we actually just want out of the structural model? We're trying to recover these unobservables of search costs, price sensitivity, and unobserved product quality. What is actually going to pin that down is actually the same variation we saw in the previous slide. So let me now conclude with some very preliminary counterfactuals results that I have for one market and focus on this particular counterfactual where we randomize the position of those 20 products that we're studying. So here we're trying to think about what if we remove that position differential that we saw between Amazon and small businesses. What's going to happen is that profits shift from Amazon to SMBs. This reflects the fact that Amazon enjoys quite a sizable market power from the status quo ordering of products. However, it's important to note that consumers would prefer the status quo ordering, but not necessarily by that much. And the reason they prefer it is because prices tend to rise when we have this randomized position situation. And so it's also highlights how it's important to have a structural model where consumers are re-optimizing their search and firms also re-optimize their prices in response to anything we're going to do to how the search results are populated. And I think I'll end it there.
Okay, Thailand, thank you very much for describing your project. I'm wondering whether you all three know each other. You knew each other before this, Luis, Thailand?
I know Francesco, so the co-author of Michela.
Okay, it can be also an opportunity for you to meet and to share your ideas and maybe to carry out. And this maybe is also an opportunity for the other people in the audience to support your projects if they think they're relevant and they need to be supported. Of course, you need to remain independent, as Tommaso said. But if there is a further support from others, that would be good as well. Now, Joe, I guess you received an envelope, right, with the name of the winner. All right, very good. Yeah, I mean, that's about competition, guys. Your research projects were all fantastic, but that's competition stuff. At the end of the day, there will be one winner. So, Joe, the floor is yours.
Okay, thank you, Paolo. It was a pleasure reading all of the proposals. And thank you, Paolo, for giving me the most exciting moment in the conference. We have 3 exceptional finalists, all of whom have put forth frontier research projects designed to address some of the most important and really challenging issues in competition policy today. In following up on Bill's metaphor, they've all planted trees, and the scientific committee believes these trees are likely to bear fruit, which will prove highly nutritious to scholars and practitioners. So, the envelope. And the winner of the 2021 Young Talent Competition Award is Michela Boldrini and Francesco Clavoro Browling for Taming Tech Giants Algorithms, the Amazon Buy Box Case. Congratulations, Michela and Francesco, and to all the finalists.
Okay, thank you very much. I'm really excited. That's wonderful. And I see that Michela is smiling. You want to say?
I don't know whether I had the chance to say thank you to everybody and to the committee in particular for, I mean, we are super, I think I can speak for Francesco as well. I'm not sure whether it's still online, but we are totally happy you thought our project is interesting, and so I really hope we'll be able to give you some results soon enough. And thank you again, and we are probably gonna approach all of you to ask for even more feedback later on. So be prepared, and thank you again.
Okay, Michela, we look forward to reading your results as well as the results of the other research projects, and hopefully you'll be able next year to present some of those results to our 2022 edition of the festival. Okay, that's it for tomorrow, but the festival is not over. It lasts 3 days, so we're gonna resume to tomorrow morning. Well, tomorrow it's at 2:30 European time. It will be morning in the US. It will be evening somewhere else. Let me thank once again Bill, Joe, Michele, and Tommaso for the wonderful support and collaboration and effort in reading the proposals, and the 3 finalists for being with us today. So look forward to meeting you, all of you tomorrow, and that's it for today. Thank
Congratulations.
You.
Bye.
Have a good day.
Thank you very much.
Bye bye.